silence, all stand.
Please open the commission.
The Royal Commission is now in session. Please be seated.
Yes, Ms Hutchins.
Commissioners, I call Ms Deborah Ann Barnes.
Do you wish to make an oath or an affirmation?
An affirmation.
Please repeat after me. I solemnly and sincerely declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth. Thank you.
Operator, you can be seated. Operator, please bring up WIT.0328.001.001. Ms Barnes, is this a copy of the statement that you've prepared for the Commission?
Yes.
And do you have a copy in front of you?
I do, thank you.
Do you wish to make any amendments to the statement?
No, thank you.
Are its contents true and correct to the best of your knowledge and belief?
They are.
Thank you. Commissioners, I tender the statement of Ms Deborah Ann Barnes dated 24 July 2019.
Yes, the witness statement of Deborah Ann Barnes dated 24 July 2019 will be Exhibit 8-43.
Thank you. Now, Ms Barnes, in your own time, could you please read from your statement commencing at paragraph 4?
Thank you. My full name is Deborah Ann Barnes. I'm 65 years old. I have previously worked in IT and HR, and I am now retired. My mum was born in Coburg, Victoria. Mum and Dad had 4 children, 2 sons and 2 daughters. Mum was a physical education teacher and lecturer in her early teaching days, and later an infants teacher and headmistress. Mum was one of 5, so we grew up with lots of aunts, uncles and cousins. Mum and Dad had 8 grandchildren and 11 great-grandchildren. For her 90th birthday, Mum celebrated with 38 family members. Mum enjoyed her retirement, and she and Dad travelled throughout Australia and overseas. Mum researched family history, learned to quilt and played cards regularly. In 2002, Mum and Dad moved to an independent villa within a retirement complex. In 2002, when Mum moved into the villa, she was generally in good health. She was managing maturity onset type 2 diabetes well with diet and daily medication. Mum and Dad lived independently and were able to cook and clean for themselves. They received some housekeeping assistance from DVA for a couple of years prior to 2017. On the 20th of December 2015, Mum fell in the villa and broke her hip. After her fall, her mobility and cognitive ability declined. It was no longer possible for her to live at home with Dad. In January 2016, Mum had an ACAT assessment in hospital, and we prepared to move her into full-time care. The ACAT assessment identified that Mum was experiencing cognitive decline. On the 4th of February 2016, Mum moved into the facility. Mum was still very much a part of the facility community while she was in that area. Mum's friends from independent living would come and visit her. Sometimes my family or I would take Mum in a wheelchair back to the villa for family gatherings, lunch or morning tea with Dad, and for Mum to check how Dad was going. When it was time for Mum to enter high care, the main factor we considered as a family was the accessibility for Dad. The facility was within walking distance for Dad to visit, which was the key reason we were happy to have Mum at the facility. At that stage, I didn't really know what to look for in terms of quality of care in the aged care setting. My sister and I became Mum's enduring power of attorney after her ACAT assessment. My sister had a full plate with her own health concerns, so I handled most of Mum's needs. I made the time to be involved in the day-to-day running of Mum's care. I would say I was the most annoying, brilliant advocate daughter that I could be. I didn't mind coming across as a busybody if it meant I could ask all of the questions that needed to be asked on Mum's behalf. During Mum's stay in the facility, I texted or emailed my siblings to keep them updated. I shared everything from hairdressing appointments to changes in Mum's health. As I was present several times a week, I was able to observe the way the facility staff handled Mum's needs, and I often provided formal and informal feedback. The facility had a paper-based feedback system. There was a folder of feedback slips available at the front entrance near the visitor sign-in book, which you could complete and put in the feedback box. I also used the online web inquiries platform on a couple of occasions. However, I never received a response from that medium. As far as I was aware, these were the only options for providing feedback in writing unless you had a staff member's email address. I regularly provided feedback via the feedback slips, both positive and areas for improvement. I estimate that I provided feedback on 50 to 60 occasions. In my experience, I only received acknowledgement of my feedback about 25% of the time, and then mainly informal. I often had to find staff in the corridors if I wanted a response. I didn't like doing this as I was aware the staff were busy. However, after being patient for a couple of weeks, I would then try and catch someone when I saw them. On several occasions, the facility ran out of feedback slips. I took to keeping a couple of feedback slips in my bag to get around the lack of slips. On the 19th of January 2018, I contacted the facility through the online inquiries form. We had experienced a recent bout of extreme heat in the area. When I was visiting Mum during this period, I could feel that the facility was unreasonably hot, and I could see that Mum and other residents looked uncomfortable. I was uncomfortable. The staff appeared uncomfortable. In my email to the facility, I noted that there had been an absence of feedback forms for the past week. I asked whether any of the senior leadership team had visited the facility during the extreme heat period, whether they would be satisfied for their family members to live in those conditions, and what plans they had in place to bring the facility up to a reasonable level of comfort. My query was never acknowledged by the facility, and I never received a response. From January 2018, I noticed that Mum was sleeping more and talking less. On the 5th of March 2018, I spoke to Mum's GP, and we discussed the fact that medication changes had not improved Mum's recent drowsiness. I told the doctor I did not want to rely on other sources of information on how we best support and look after Mum. I also said that I want to understand better where Mum is at so we know what to expect from the staff at the facility, and so we can all do the best for her. After this discussion with the doctor, I requested a meeting with the key care staff to talk through Mum's care plan. The meeting was scheduled for the 21st of March 2018. In early March, I had several conversations with staff members about Mum's care plan being updated. The conversations were always in passing, and I felt like I wasn't getting a clear answer. The clinical nurse educator told me there was a note in Mum's file that I was consulted on the 6th of February 2018 and that Mum's care plan had been updated. I explained that I had never seen a care plan, let alone been consulted about updating it. The clinical nurse educator told me the problem is because you're here so often, we don't get as formal. On the 19th of March 2018, I emailed the clinical manager, a senior staff member and the CEO of the facility and advised that I thought that there had been a communication breakdown. I wrote that I knew what information I had shared with the staff at the facility, but that I was not clear on what information I should receive back, through which medium, and how regularly. I told them that I needed information to be formally shared with me and not just conversations in passing in the corridors. I asked what else is being done or should be done to ensure that we all look out for Mum as best as possible. In response to my email, the clinical manager advised that she would join the 21st of March 2018 meeting to discuss my concerns. On the 21st of March, I attended a meeting with the clinical manager and another RN. I felt it was bumpy in spots, but overall a productive meeting. My goal for the interaction was to focus on the message on providing the best possible care and support for Mum. I was hopeful that communication was going to flow better between the facility, Mum and myself. In and around mid-April 2018, I realised that Mum had missed another of her regular hairdressing appointments. Mum had always taken pride in her appearance, and having her hair washed and styled at the hairdresser was an important factor in maintaining her quality of life. By this stage, I had seen a draft of Mum's care plan at the meeting on the 21st of March. Mum had standing twice-weekly hairdressing appointments recorded in her care plan. I asked the RN responsible why Mum had not been taken to her appointment. The RN said that she didn't realise that this was in Mum's care plan and wasn't sure what had happened. After a short time, the RN came back to see me. She told me that the care worker who was scheduled to take Mum to her appointment was called away to another area and wasn't able to come back. After learning this, I called the hairdresser directly. The hairdresser told me that when she realised that Mum had not arrived for her appointment, she called the facility and nobody answered the phone. The hairdresser said she also called again in 2 hours' time, and again, nobody answered the phone. These appointments were important to my mum and were recorded in her care plan. I felt really let down that the facility staff were not communicating with each other to ensure that Mum was cared for in accordance with her plan. Also, I witnessed the difference it made when Mum had had her hair done. People would stop and comment on how lovely Mum looked, and Mum would respond or smile. I submitted a feedback slip to share my concerns. The clinical nurse educator called me later that night. We had an awkward conversation in which she aggressively asked me why I had put in written feedback when I could have spoken to her directly. I had been told time and time again that the facility welcomed feedback, so I was overwhelmed by the clinical nurse educator's response. I asked that we end the phone call because I felt extremely uncomfortable and I could not believe what I was hearing. After the phone conversation, I emailed the clinical manager and a senior staff member and requested that any future discussion about feedback or mum's care not involve the clinical nurse educator. Disappointingly, no one even acknowledged that email or issue. I saw the clinical manager 2 weeks later in the corridor and asked her about it. She said to me, "It's all in hand, you don't need to worry about it." I felt dismissed and disappointed. I felt that the communication continued to be an issue with the facility as time continued. On the 23rd of May 2018, I received a call from the facility to inform me that Mum may need to go to hospital because she had perspired so heavily that her sheets were wet. I was shocked because I had been there that day and I had told staff that if Mum was sick, then of course they should send her to hospital. I waited with Mum before the ambulance took her to hospital. I consulted with the emergency doctor and the RN who told me that Mum had a UTI and a high blood sugar reading. The RN explained to me that Mum's blood sugar would rise with an infection. From about January 2018, Mum had been speaking very little. When she was diagnosed with a UTI, it became clear to me that Mum had not been able to tell staff that she was uncomfortable, which meant that they did not realise she had a UTI. My key focus after the emergency room visit was to ensure the facility had measures in place to prevent and identify any future infections. I sent several emails and spoke to different staff members about strategies that could be put in place to monitor and prevent further infections. The clinical manager offered an option of monitoring Mum's fluid intake to make sure Mum was drinking plenty of fluids. I told her that Mum needed prompting to drink at times. On the 2nd of June 2018, I visited Mum for the afternoon. I found that there was no cup of water available for her to drink and I had to get one myself. That happened regularly. If there was a water cup and a water jug on the bedside table, it was often out of Mum's reach when she was in bed. Mum's fluids were to be monitored over 2 days. The RN on duty on the Saturday after the monitoring period finished assured me that Mum had healthy numbers on her fluid intake sheet. When I followed up and questioned that further, the clinical nurse educator told me that the fluid intake sheet only records what drinks Mum had been offered and that it didn't capture whether or not she drank them. I challenged the numbers as I had been with Mum from 10:30 a.m. to 3:30 p.m. on the Wednesday and no one asked me about what Mum had drunk or been offered. On the 4th of June 2018, I spoke to the clinical nurse educator in the afternoon about why nobody was making sure Mum was getting the fluid she needed. The clinical nurse educator told me they did not provide acute care and it was up to Mum as to what she did or did not drink. I was feeling incredibly confused and frustrated because I simply couldn't understand how how that would not be a part of the care that they would offer mum. At that point, the clinical nurse educator told me that I could be intimidating and that perhaps staff didn't feel comfortable approaching me with problems or information. By that stage, I had serious concerns about the facility's ability to care for mum. I made inquiries at a new residential aged care facility closer to my home and arranged to have a tour. I found a geriatrician who was prepared to visit mum at the facility. The geriatrician advised that unless there was a major concern, we should keep mum at the existing facility because she was familiar with her surroundings. In or around July 2018, the clinical manager informed me that they needed to swab a pressure injury on mum's buttocks to test whether there was an infection that required antibiotics. On July 2018, I wrote to the clinical manager and asked for a meeting to discuss how long mum had had the pressure injury, what had been done, and how could I track the treatment progress. At our meeting, I was told that the injury had been identified in January 2018 and was being monitored. I had been aware of the pressure sore for a little while, but not from the beginning of 2018. It felt like I was not being told any or given updates unless I proactively asked for them. On about the 20th of July 2018, my elder brother and I requested the facility undertake an internal investigation into mum's care. The facility provided a report to us on the 24th of July 2018. The report recorded that staff were relying on word of mouth rather than utilising the communication book. It also noted that there were annual care planning education sessions for nursing staff. The facility advised that they plan to make these sessions mandatory every 6 months. On the 2nd of August 2018, my sister visited mum and found her asleep at about 9 a.m. Mum couldn't be roused and was taken to the emergency department. The doctors tried to assess mum's blood sugar levels with a BGL machine. Her levels were too high for the machine to read. Doctors also found that mum's stomach was distended due to urinary retention and a urinary tract infection. Mum passed away in the palliative care unit at the hospital on the 9th of August 2018. I was saddened and frustrated with the communication I had with the facility in mum's last 6 months of life. At several different stages, I felt like my voice was not being heard and that I was powerless. I did not know who else I could talk to about my concerns. The facility did not tell me about any external complaint services that I could access. As mum's power of attorney and loving daughter, I felt responsible for ensuring that she was receiving the best possible care. I wanted to be kept informed and involved with decisions and in any developments about mum's care. After mum passed, I was left with an overwhelming and absolutely certain feeling that she didn't get the care that she should have received. I spoke to a lawyer who had helped with Dad's estate and asked who I could turn to for help. The lawyer recommended contacting the Office of the Health Ombudsman. In mid-September 2018, I contacted the Health Ombudsman to raise my concerns about mum's care and subsequent death. Within a week or so, I was informed that they had referred my complaint to the Aged Care Complaints Commission, now known as the Aged Care Quality and Safety Commission. I was assigned a case officer at the Commission who helped me understand the complaint review process. I was told that my complaint was being triaged and they would return to me with an update as soon as possible. My case officer was very clear about the Commission having processes that they need to go through to investigate complaints. She emphasised that there was no guarantee of an outcome. I provided all of the documents I had available, including files I had obtained through a Freedom of Information request from the hospital. I contacted my case officer in September and October 2018. By November 2018, I had not received an update, so I sent an email to my previous contact at the Commission asking if she would send on to the correct person, as I did not have their email address. The Commission told me by phone that my complaint was still in the queue. The person that I spoke to acknowledged they had said they were going to provide regular updates and apologised for the lack of communication. I contacted the Commission again in mid-January 2019 because I had still not received any updates. A case officer responded and said that my emails may have been lost in the system as they were having technical issues since moving to the new Aged Care Quality and Safety Commission. My complaint was then sent to the clinical assessment team at the Commission to evaluate mum's care. I subsequently received a draft report from the Commission and I was given an opportunity to provide feedback on that draft, which I did. On the 12th of April 2019, the Commission advised me by letter that a decision had been made to end the resolution process on the basis that the facility had addressed the issues to the satisfaction of the Commissioner. The Commission found that the facility did not meet an expected level of clinical care when assessing and transferring mum to hospital on the 2nd of August 2018. The Commission also found the assessments conducted by the facility were not comprehensive in that they did not adequately identify mum's changed care needs. The Commission found that the facility had implemented a range of quality improvements, including a dedicated assessment tool for acute change of status, a review of policies and procedures, and provision of training to staff. These actions were found to have satisfactorily addressed the facility's failure to provide clinical care of a required standard to my mum. I do not understand how the complaint could have been resolved without there being an acknowledgement of what actually happened to mum and who was accountable for it. The Commission report also did not identify that the facility's standard review and continuous improvement practices had failed to identify a number of areas for improvement. My complaint was a non-standard input to a review and continuous cycle. In my opinion, there should be standard inputs to the aged care provider's reviews and continuous improvement cycle, such as frequent reviews and education sessions with staff. The facility noted in their response to the Commission that they had implemented a range of new education and policy measures. I am concerned that if I had not complained, these improvements would not have been made. It felt like the facility was reactive rather than proactive, and the Commission was satisfied with that approach. I was not satisfied when I received the Commission final report. I felt that the Commission had simply been through the steps of a process rather than critically assessing the outcome to see if it was reasonable and fair. On the 14th of May 2019, I sent an email to the Commission requesting an internal review of the decision. In my request for a review, I wrote that I thought some of the information provided the facility should be clarified because I felt the Commission review and the facility's response did not address all of the matters that I had raised in my complaint. On the 11th of June 2019, the Commission advised by letter that they had reviewed the findings that were the subject of my review and had decided not to investigate further.
Were you told why?
They were satisfied with the information that they had received.
Do you know what that information was?
No.
No further questions, Commissioners.
Thank you very much, Ms Barnes. It's been a very enlightening opening to the morning's proceedings, and we're very grateful to you for having shared your shocking experiences with us. Thank you. You're excused from further attendance.
Richard Knowles will call the next witness.
Thank you, Commissioners. I now call Ms Shona Reid from the Aged Care Quality and Safety Commission.
Please repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Ms Reid, can you tell the Royal Commission your full name?
Shona Leanne Reid.
Yes. And do you have before you both a statement and a subsequent annexure to that statement that you have prepared for the Royal Commission?
Yes, I have.
And is the statement dated the 26th of July 2019?
Yes, it is.
And that is document WIT.0307.0001.001. And the annexure is, so far as I can see, not dated, but that is the document that I take it you have before you, which has a document number in the top right-hand corner of WIT.0307.0002.001.
Yes.
Thank you. Now, have you read firstly the statement lately?
Yes.
And have you read the annexure as well lately?
Yes.
Yes. Are there any changes that you wish to make to either of those documents?
Yes, at number 12, I need to change the number.
Sorry, this is at paragraph 12 of your statement, is it?
Yes. There's a number that's incorrect, the number of issues.
Thank you. What do you wish to change that to?
It should be 18,000.
190 issues?
Thank you.
Thank you. Are there any other changes that you wish to make to the documents?
No.
In respect of your statement, subject to that one change to paragraph 12, are the contents of your statement true and correct to the best of your knowledge and belief?
Yes.
Yes. I seek to tender the statement Commissioners.
The witness statement of Shona Leanne Reid dated the 26th of July 2019 as amended, and the annexure thereto will be Exhibit 8-44.
Thank you, Commissioners. I don't believe that I directly asked Ms Reid about the contents of the annexure. I might just do that now, just to confirm. You've read the annexure lately. I take it you don't wish to make any changes to that document?
No.
And the contents of that too are true and correct to the best of your knowledge and belief?
Yes.
Yes, thank you. Now, Ms Reid, can you tell the Royal Commission what your present position is?
Yes, my position is Executive Director of the Complaints Resolution Group, and my role my title is Performance, Education and Policy.
Right. So are you heading up the complaints area within the Quality and Safety Commission, are you?
No, I share that role with another Executive Director who's the National Complaints Manager.
Right, I see. So you have joint responsibility for that particular role, is that correct?
No, the National Operations Manager has responsibility for all of the operational complaints functions and processes, and I have responsibility for some operational areas such as the clinical unit, the review function and a complex case area, and then I have support functions reporting to me, which are the legal area and training and policy and procedures and support for complaints officers. So the Executive Director and I work very closely together. I'm also responsible for the case management system and reporting and analytics.
Yes, thank you. And you previously to occupying this position with the Commission,
yes,
occupied a position with what was the Aged Care Complaints Commission?
That's correct.
And can you just describe when you occupied that position and what it was?
Okay. I moved into that, previous to moving into the role in 2016, I worked for the Department of Health transitioning the previous Aged Care Complaints Scheme to the new Independent Aged Care Complaints Commissioner, and started in that role as Assistant Commissioner on the 1st of January 2016.
Yes. And you had, what was the role that you started in 2016 and that continued up until the transition across to from the Complaints Commission to the Quality and Safety Commission?
Broadly the same role that I have now.
Yes.
With the addition of FOI that I now have for the whole organisation.
Yes, thank you. And I take it, therefore, from what you've just said, you're quite familiar with the two ways in which previously complaints were handled by the Complaints Commission and presently the complaints are handled by the Quality and Safety Commission.
Yes.
Yes. And you've referred to that in your statement at paragraph 17 and following, haven't you?
Yes.
And at the end of paragraph 17, you say that there are no substantive differences in the acts and rules setting out the complaints handling processes adopted by the Quality Safety Commission and the Complaints Commissioner, respectively.
That's correct.
You then say there are, however, differences in the approaches to the complaints handling processes as between the Quality Safety Commission and the Complaints Commission?
Yes.
Yes. Now, before I come to that, you've then set out at paragraphs 19 the rules as they presently stand, and at 20 you say that those rules broadly reflect what the contents of the rules were previously.
Yes.
Then at 21 you say the differences in the approaches to the complaints handling processes as between now and previously include, and you set out various matters.
Yes.
Now the first relates to intake of complaints, and you say in the third line of that subparagraph A that the Quality and Safety Commission is in the process of considering recommendations to redesign its intake process.
Yes.
So that hasn't actually changed as yet. Is that correct?
Yes, that's correct.
And then you refer over the page, at the top of the page, still in subparagraph A, to plans to implement an organisation-wide web form. But I take it, again, that actually is not implemented as yet?
That's correct. We have a web form, but it doesn't pre-populate or automatically populate our case management system.
Right. Is that the same as the web form that existed previously?
Yes.
Yes, thank you. Otherwise, in terms of the actual process for complaints handling, you don't refer to any specific differences in paragraph 21, do you?
No.
No. And so am I right in thinking that at present there's no real difference in the complaints handling procedure now to what went before under the Complaints Commission?
That's right.
Thanks.
If you're talking about process.
Yes, I am. I mean,
sorry.
I take your point that you've said, well, now there's a reorganisation formally of the entity that deals with complaints, that it's now brought into the Quality and Safety Commission, and you make that point there.
Yep.
But the actual process itself, you accept, is substantially the same as went before.
Yes,
at
the legislation's
time.
the same. Yes.
The legislation's the same,
Yeah,
and in
which
terms
drives our
of
processes.
how it's administered, that's still substantially the same.
Yes.
Thank you. And you have, as I say, observed that in a formal organisational sense, the Complaints Commission's functions are now performed by the Complaints Resolution Group within the Aged Care Quality and Safety Commission.
Yes.
And are you aware of the evidence that was given earlier this week by Ms Tracy Rees of the Quality and Safety Commission that, at least in Queensland, and this was given in the context of the People Care case study, the Quality Assessment and Monitoring Group is separate from the Complaints Resolution Group in terms of their physical locations?
Yes, that's correct.
And those physical locations reflect where the two bodies were prior to the Complaints Resolution Group coming into the fold, so to speak?
Yes.
That is, into the fold of the Quality and Safety Commission?
Yes.
Yes. And did you hear the evidence that was given by Ms Rees also that each of those groups within the Quality and Safety Commission still has a different IT system?
Yes, that's correct.
So is it fair to say that in a practical sense there remains some legacy of the former separation of these two areas, at least in Queensland?
It probably is a national...
It's a national?
Yes. The computer systems are separate nationally.
And does offices, do they remain separate nationally as well?
In most offices, except for the ACT, and I think Tasmania currently.
But otherwise they still remain in separate physical locations?
Yes.
Now, in your statement at paragraph 21, subparagraph A, Roman numeral 1, you've indicated at the bottom of that passage that in the first 3 quarters of 2018-19, approximately 30% of contacts with CRG were not within the scope of the Aged Care Quality and Safety Commission's remit.
Yes.
What were those kinds of complaints that were found not to be within the remit of the Quality and Safety Commission?
Well, when people phone us, we try and help them as much as we can. So they're types of questions about retirement homes. They might be questions about issues to do with access that My Aged Care could deal with better. sometimes people want to know how to get to the doctors and which buses to get, and we try and help as much as we can, and we spend time. We get a lot of Telstra complaints because people and those kinds of things that are not within our remit.
Yes.
And what we do is we try to refer them to the appropriate body, and we have a great long list of appropriate bodies in our offices to try and help people. But they take quite a lot of time and discussion with helping complainants who ring us.
Do you think that might reflect some lack of awareness on the part of those that ring you about the function of the Quality and Safety Commission's Complaints Resolution Group and what it can do and what it can't do?
Yes, particularly retirement homes, because they're not government funded, so therefore they're not within our remit.
Yes.
They're the state bodies that need to help them, and the state bodies do advertise that, you know, they take complaints as well. So.
And have you given any consideration as to how you might, in terms of an organisation, perhaps inform people better about what the function of the Complaints Resolution Group is?
Yes, well, that's been an ongoing piece of work, even from when I first started working for the previous Commissioner. And the Commissioner will present and go to presentations. We offer education on site. We offer education at senior groups and other consumer type bodies where we take along information and explain to people what we do. Whenever we're invited, we never say no. We do go, and we have had education sessions with the My Aged Care staff to help them understand what we do. We've had education sessions in the past with, we've sent letters to the visitors scheme to help them understand what we do. We have shared education sessions in the past with the advocacy group, so they understand what we do and we understand what they do, all those kinds of areas. Promotion of what we do, we provide free external information to the public, and that's a huge take-up. I haven't got the numbers with me today, but they're in the thousands. And yes, we are promoting.
Yes.
And I guess our complaints have increased, and that's
yes. Well,
also
that
media. When there's media
yes.
About us, more
yes.
people know about us.
Well, that was my next topic that I wanted to turn to. You refer to that in subparagraph A of paragraph 21, that there's been an increase in the volume, and if I can bring up as well, beside your statement on the screen, tab 125 of the general tender bundle. And do you see that there, Ms Reid, the complaints data document supplied by the Commonwealth shows that complaints have increased in the last 4 years from 3,744 complaints in the 2014-15 year to 7,828 complaints in the 2018-19 year?
Yes.
Has any consideration been given as to why that increase has occurred to that extent?
We think it's predominantly, as I said, more interaction over the past 3 years and continuing on with the general public and promoting who we are and what we do. In addition to that, I believe it's been media, it's been announcement of the Royal Commission, and that way more people have found out who we are, which is good.
Has any consideration been given to the possibility that it might reflect increasing levels of substandard care?
Well, you would have to think that more complaints mean more problems and more issues in services. There are 1 million people receiving care, and there's 7,828 complaints and over 18,000 issues that we deal with every year, I would think there probably is a lot more complaints and a lot more people that don't know about us.
Now, in terms of that increase in complaints, what's been done within the Quality and Safety Commission and its predecessor, the ACCC, the Aged Care Complaints Commission, in terms of resourcing and staffing levels to deal with that? Have there been commensurate increases in staffing levels?
Well, since the beginning of January, we have 8 more complaints officers, so we've employed 8 more operational complaints officers than we had from the 1st of January. We're also looking at those areas, that 30% that you were talking about that's not within our remit, and we are currently trialling some set of more direct questions to try and see if that we can reduce the time frames that we are dealing with those out of scope or calls that aren't within our remit, to free more time up to spend on complaints. There is constant, as I said to you, I look after the analytics, so we do see trends, we do see areas where the complaints are increasing and issues are increasing, and that's communicated to the Commissioner currently by the National Operations Manager, and they're having they meet fortnightly, and monthly their discussion is about the statistics and how things are going. I have confidence, and I know that the Commissioner has discussions with the Department of Health about resourcing and appropriate resourcing for the organisation.
You said before that you've had 8 more staff members appointed. Do they 8 more staff members dealing directly with complaints? Is that right? And
that's right.
Since when was that? Since
the 1st of January this year.
And what does that bring the total number of staff members across the country dealing with the complaints that are brought to the Commission's attention?
It's 181 FTE for the whole group, and about 123 FTE of complaints officers.
So 123 full-time equivalent workers in terms of the complaints function across the country, and that's to deal with some 18,000 issues raised per year?
Yes.
Okay. Now, I take it you'd agree that a proper complaints handling process is absolutely vital to good regulation of aged care?
Absolutely.
And you would have heard the evidence, I take it, given earlier by a colleague of yours, Ms Catherine Rosenbrock, that but for the complaint made by Ms Johanna Alberts-Henderson about her mother's treatment at Avondrust, it was unlikely sanctions would have been imposed on MyCare when they were. And she made it clear that external sources by way of complaints were the most valuable source of information available to the Quality and Safety Commission. Do you recall that?
Yes, I do.
Yes. Now, can I take you, bearing that in mind, can I take you to the document at tab 71 of the General Tender Bundle? This is a document produced by the Quality and Safety Commission dealing with how complaints might be dealt with through early resolution. Can I ask you to explain to the Royal Commission the various ways in which complaints might be dealt with? And I know you've set this out in your statement, but perhaps if you could just go over that now before we go to this document.
Okay. So we offer a free service, and we offer a service where people can phone in, and the majority of our complaints are by telephone. People can use the web form, and that's emailed to us, and we will call people back to then discuss their issues that they would like to raise. So it's a free service. People can make that complaints anonymously or confidentially. Once we receive the initial complaint at intake, we will then have several discussions with the complainant sometimes, or it might be at the first discussion, that discusses what their issues are and also what outcome they're seeking. Many complainants come to us and the outcome that they're seeking is an apology from the service and also improvements in care for everybody else in the service, including their loved one if they're still in the service. So that's sort of the main outcome that they're looking for. We then risk assess very quickly and determine what escalation timeframe the complaints officer needs to escalate that to their complaints manager. It might be a moderate, which would be within 48 hours, a discussion with their complaints manager. It might be major, which would be 24 hours. They need to escalate that to their complaints manager, or immediate, and then it needs to be escalated to their complaints manager immediately. And often that would mean a discussion with their complaints manager about undertaking one of those type 3s that you were talking about. And then if it was determined that there would be a type 3, that would a copy of that would be given to the Department of Health, and our quality and monitoring group and the National Complaints Manager would discuss what happens next.
So in terms of, I understand that process, but in terms of making a decision about whether or not something's dealt with through early resolution or otherwise, can you explain when that decision's made and what the difference is between dealing with a complaint through early resolution,
yes,
and through referral to the resolution team, I think it's referred to?
That's right. There's two parts. So after that escalation discussion, the complaint will be dealt with in early resolution, and or it may be determined after another risk assessment that the complaint is more complex or needs to use a different tool, such as investigation or conciliation, mediation, or provider resolution, and then it will move to the resolution phase.
Right.
The resolution phase does take longer.
And is more detailed,
yes,
in terms of the scrutiny that is given to the particular complaint and the issues raised by it.
Yes.
So in terms of what we see on this first page of the document, how do I handle a complaint through early resolution?
Yes.
Do you see the heading, what types of issues are suitable for early resolution? It says underneath that heading, we finalise a very large proportion of complaints at early resolution, therefore all issues are potentially suitable for early resolution unless there is an immediate risk to care recipients. And then there's some circumstances of the exceptions where one might not find a case to be suitable for early resolution.
Yes.
Do you agree that what this document would tend to suggest is that early resolution is encouraged wherever it is regarded as possible?
Yes.
And do you agree also that in the ordinary course it's usually regarded as possible?
Yes.
And going back to the document that I took you to earlier about complaints data at tab 125 of the general tender bundle, if we go to the second page of that document, this is just in relation to statistics since 1 January this year up until 30 June. You see that there are 3,545 complaints finalised in the second line there.
Yes.
And then there's a reference to number of complaints finalised at early resolution during this period, and it's 3,496.
Can I just
Yes.
clarify? I think that's issues.
I see.
Yeah. When a complainant makes complaints, on average there's 3 issues per complaint.
So why do you say that's issues and not complaints?
Because each issue may have a different resolution process depending on what the issue is. So the issue could be the service has lost my laundry, or it might be the medication wasn't delivered on time to my mother. So they're separate issues and they would be treated as separate issues. But I'm just looking at the footnote to see. There's a footnote on that page.
Yes, perhaps if we can zoom out from the page and then the footnote. Thank you, operator.
So it talks about issues
in footnote 5, but I mean, you've already seen the evidence that there were some 7,800 complaints last year.
Yes.
Given that we're talking about half a year, this would tend to suggest that this is referring to complaints as distinct from issues for a 6-month period, wouldn't it?
Yeah, it would, yeah. I could be wrong. It could be complaints.
So if we go back to those figures that are on the screen, would you agree that what that does is bears out what you've already acknowledged, that the vast majority of complaints are finalised at early resolution?
That's correct.
Yes. Now, can I take you back to your statement in paragraph 55? And there you refer to how the Quality and Safety Commission assesses effectiveness of its complaints handling function. And you refer to several measures that it looks at in order to assess the effectiveness of the complaints handling function.
Yes.
And save for E, that is subparagraph E, they are all matters that go to the timeliness within which complaints, the first 3 go to matters relating to timeliness within which complaints are finalised. Do you agree?
Yes.
And the 4th goes to how the complaint was resolved. So that's not particularly pertinent here, but
yes.
But then the 5th refers to number of complaints about our service. So is that the only one of those things that you've referred to that might possibly concern any feedback is the 5th one, is that right?
There are complaints about our service, but we also provide a survey to complainants and receive an indicator of satisfaction rating.
Yes. So I was going to ask about that. You've referred to that survey in your statement at paragraph 58.
Yes.
You haven't, you've just referred to, if we perhaps keep both pages up, the former page as well, in containing paragraph 55. Thank you for that. You haven't referred to survey feedback there in 55, have you?
No.
But do you now say that that is something that is used to assess the effectiveness of complaints handling functions?
Yes, it is, but it's not. It doesn't go to timeliness.
I understand, but it's one of the matters that you take into account to assess how effective the Quality and Safety Commission has been. Is that right?
It's an indicator.
Okay. All right. And do you agree that that survey and those results should be really the critical matter that ought to be taken into account to assess the effectiveness of a complaints handling scheme, given that it is there, after all, for the complainants?
Yes.
Now, in that regard, you say at paragraphs 58 through to 62 of your statement, if we could bring up those 2 pages now, that what those surveys have shown is that the satisfaction, overall satisfaction of survey respondents and you've described how that is measured in paragraph 59. The overall satisfaction for the last year of survey respondents was a little under 75%.
Yes.
Yes. And so from that, do I take it that 1 in 4 people who completed the survey were not satisfied overall with the complaints handling function by the Quality and Safety Commission or its predecessor?
If that's how the maths work out, yep. I can work it out.
Well, 25% is equivalent to a quarter, so would you agree with that?
Yep.
Does that strike you as a good outcome?
It's not ideal. I mean, we would strive for 100%, and some complainants are not happy with our outcomes.
Well, this survey, I take it, goes to not the outcome but the process and how it is handled. Is that fair?
It is, but it also in the mind of complainants, I think, is the outcome that they've received from us, or the decision that we've made.
Mm-hmm. And does that go to perhaps explaining to complainants what the process is better? Or not doing it effectively enough?
Can you repeat that question, please?
Sorry, I'm not very clear.
Right.
So does that go to a lack of effectively explaining to complainants what they can expect to obtain from the process?
I think it's so it's about 52% of the early resolution complaints are resolved to the satisfaction of the complainant. So that leaves another percentage where we make the decision that the Commission is satisfied with the outcome or the changes or the work that the service has offered up or put into place to improve care into the future. Complainants are not always happy with that outcome. Some complainants are seeking more punitive action, and our aim is to get the service to improve, fix care, and have a much better improved care for care recipients.
Now, the level of overall satisfaction of 75%, that fell short of the Quality and Safety Commission's aspirational target of 85%?
Yes.
Yeah. So that aspirational target of 85% is one in which I take it, Quality and Safety Commission considers that provided that only 1 in 6 people are dissatisfied with the service, that's okay?
It's not okay. I would prefer all complainants were happy with our service and happy with our outcomes. So we need to constantly be talking about where we can learn, where we can improve, to meet their expectations.
Now, in your statement at paragraph 58, you say in the first sentence that the Quality and Safety Commission issues a survey to those complainants who are not within particular categories, so those who are anonymous, those who withdraw the complaint before the point at which the survey is issued, or for those who choose not to participate. So there are certain people who do not get a survey.
That's right.
Why wouldn't you give a survey to people who withdraw from the process, given that they may do that precisely because they're dissatisfied with it?
I don't know, but I think that's something I should look at. I agree.
Now, in paragraph 67 of your statement, you have referred to, pardon me, paragraph 64, pardon me, you've referred to key performance indicators for staff who handle complaints, and you say that those KPIs are informed by timeframes with respect to the triaging, resolution or referral of complaints and the 6-monthly operational plan. So am I right in thinking that that places some considerable significance on timeliness of resolution of complaints?
Yes, that's referring to the 30 days, 60 days and 90 days KPI.
Yes, so they are actual stated key performance indicators set out for workers in terms of how they ought to resolve complaints as promptly as they can.
Yes.
And is there a stated KPI in relation to complainant satisfaction with the process?
Do you mean, what do you mean?
Well, in terms of...
Is there an indicator that we're... Is there
yes.
Yes, there is, yes. I can tell you
yes.
what they are now, if you like.
Yes, what is that?
So currently we're at 59% of our complaints are completed within 30 days and 82% in 60 days and 92% in 90 days.
I see. So that's in terms of timeliness, but I'm asking you about whether or not there's a key performance indicator that goes to how someone deals with complaints being to the satisfaction of complainants. Is there any measurement of that for the purposes of...
There's not a measurement, but we do know that 90% of our complaints are dealt with at early resolution.
Again, I'm asking you as to whether or not...
I'm not understanding.
I'm sure I'm just not being clear, Ms Reid, but
it could be me.
What I'm asking you is to whether or not there's any key performance indicator for staff that is measured by way of complainant satisfaction about the process. Not timeliness issues, not how speedily things are resolved, but rather the qualitative satisfaction that complainants might have. Is that
there is we do look at the number of complaints carried over each month, and we do look at that by state, and the National Manager of Operations gets monthly reports where she will get information about how we're tracking in the workloads, and she will have discussions with the Commissioner about that and other executives in the organisation.
What do you mean by carried over each month? You just mean that they haven't been finalised?
Yes.
So
yes.
That's again going to timeliness, is it?
Yes.
All right. Well, perhaps I'll move on to your annexure. Now, in that, you have dealt with or provided the description of the then Complaints Commission's response to 2 specific cases.
Yes.
The first one is the complaint that was made by Ms Sarah Holland-Batt, and that was about her father's treatment in aged care. And the second was the complaint made by Ms Lisa Backhouse on behalf of her mother. Yes.
Yes.
Now, in doing that, you've consulted the Commission's records. They're referred to in your annexure.
Yes.
Did you also read the statements of Ms Holland-Batt and Ms Backhouse that have been given to the Royal Commission?
Yes.
Yes, thank you. And have you had an opportunity to see their testimony that they've given to the Royal Commission orally?
I was able to listen to Ms Holland-Batt. Ms Backhouse, I heard parts of it.
Yes. And so I take it from that you're fully aware of the issues in each of those complaints?
Yes.
Yes. And in the case of Ms Holland-Batt, as you'll be aware then, she raised concerns about her father being a victim of abuse.
Yes.
At the hands of a staff member, and otherwise raised concerns about the clinical care that had been given to her father.
Yes.
And Ms Backhouse raised concerns about her mother's continence care, falls management, pain management and nutrition and hydration.
Yes.
Okay.
That sounds right.
Now, in both those cases, the complainants were advocates for the aged care recipients. What proportion of complaints are made directly by care recipients themselves?
Gosh, I haven't got that with me today, but I can get that. We do statistically break that down.
That would be something that, if you could
Yes.
provide that to the Royal Commission, it would be appreciated.
Yeah.
Firstly, would that be capable of being broken down by care recipients directly making the
Yes.
complaint?
Yes.
Care recipients' relatives or other informal advocates who make complaints?
We call them representatives, family
Yes.
members and representatives, yes.
And staff? Do you break it down by reference to staff who make complaints?
I think it's other, but I'll when you get the data, I'll see what I can get for you.
What about advocacy groups and community visitors? Are they identified as a separate category in terms of the source of a complaint?
I'm sorry, I can't visualise the data.
Yes.
I can only visualise the representatives, which is the majority. The majority is family and representatives.
Yes. Now, that when you say the majority, is it a sizable majority of complaints that are made by representatives being family members or informal advocates?
Yes, I'm
Yes.
visualising a pie chart that I'll give you, but yes, it is.
Yes. Is it well over a half in that visualisation of a pie chart in your mind? I'm not going to hold you to it.
No,
given
it's
that-
okay. I think it is.
Yes. We'll
Yep,
receive that information
Yes.
from you in due course.
definitely.
But given what you've just said about it being a fairly high number or high proportion of complainants being relatives or informal advocates,
Yes.
do those proportions point to a need for the Quality and Safety Commission to provide support for complainants who might not have supportive relatives or advocates?
Yes. When people call us, a lot of people who call us are grieving, angry, emotional, and it's really hard to make a complaint in aged care. It's not easy, and I think you've heard over the course of people giving that information, it's really difficult. So we do recommend that people go to the advocacy groups, go to OPAN. They're a critical stakeholder for us. We can also support people by letting them make their complaint confidential or anonymous. We also coach and give enormous support to complainants if they would like to raise it with their service provider in the first instance, which is our preference. If the service provider can resolve the issues, be open and transparent and have good complaints management practices in place, the relationships are much better. The previous Ms Barnes talked about the relationship breakdown. So with services being able to do that, the relationships are preserved as well.
These are people who've already come to you, I take it, where you provide that support.
Yes.
How do you support people in coming to you in the first place?
In that way, with the...
Understand my question?
No.
Well, pardon me.
I thought I just answered it, sorry.
How does the Quality and Safety Commission support people to make complaints when they don't have an advocate for them, or when they, perhaps even more so, don't have an advocate and may have difficulties in communicating a complaint due to cognitive decline, communication difficulties, very limited mobility and the like?
So there's a lot of options. One is to refer to the advocates. There's an option for complaints officers to invite the complainant into our offices to have a face-to-face conversation. There's an option where a complaints officer can go out on site. If a complaint's raised by somebody who's not a legal representative, we will go out and talk to the care recipient and check whether they do want to raise the complaint.
Yes,
Often.
but what is done to actually support people to make the complaint in the first place when they might have obstacles to doing so, to even taking that first step?
We will go out on site if we need to, and we will sit with the care recipient and talk to them about their complaint to try and define what those issues are.
You mentioned advocacy groups a moment ago.
Yes.
Did you hear the evidence of Ms Natalie Siegel-Brown yesterday that in this regard there's a need for a professional and fully funded community visitor program?
Yes.
Do you agree with that?
Yes. There currently is a federally funded community visitors scheme, and a year ago the previous commissioner wrote to all of those people in that scheme, inviting them to have an education session with us, and we did do several, and in the letter it gave information to them that they could raise complaints with us.
Do you regard... withdraw that. Now, in both these cases, the complaints were dealt with by way of communications by telephone or email. Is that your understanding?
Definitely, Ms Holland-Batts, yes.
There was no face-to-face meeting?
No.
Do officers meet people face-to-face in the majority of cases?
No.
Why not?
They try to, and they do successfully, discuss over the phone what the issues are that the complainant wants to raise and what the outcomes are. We call it defining the issues, and they spend a lot of time making sure that they get that right over the telephone, and most of the time they do. As I said, if there is problems and they're having a hard time or it's not working, being able to define the issues or understand what the complainant would like to happen, we can offer. We can offer to come out and meet them, or as I said, we can offer for them to come and meet us.
Well, you've given evidence about the number of staff, 123 full-time equivalent staff.
Yep.
And they're situated all in capital cities across Australia, and they're divided into regions, is that right?
Yes.
So one region, which is staffed by personnel in Adelaide, covers the whole of South Australia, Northern Territory and Western Australia?
Yes.
So
there are people in our Perth office as well.
I see.
Yeah.
I see. So, but there are difficulties, perhaps I'll put it to you, in terms of just getting to people in regional and remote areas?
Yes.
Yes. Now, you've identified in your annexure various ways in which you perceive there to have been some shortcomings in the complaints handling process for each of Ms Holland-Batt and Ms Backhouse.
Yes.
And for Ms Holland-Batt, that's referred to in paragraph 18 of your annexure. Now, you've firstly acknowledged that the response, and this is at the top of the page, to the allegations, given their seriousness, involving, among other things, allegations of abuse by a staff member, was too slow. Yes. Did you look at why that occurred in this case?
It was given a major rating, and I talked before about the escalation process, so that should have gone to the complaints manager within 24 hours. The discussion was held, but the decision, in my view, is that the service provider should have been called earlier than within 2 days to discuss those issues.
But this is also going to the response time. They were given a week to respond to the allegations, weren't
Yes,
they?
yes.
So this goes to allowing them that time while there were allegations on foot that there was potentially a staff member at the premises who was engaging in abuse of at least one resident.
Yes, and when we did ring the service provider, they informed us that they were undertaking an investigation into the behaviour of the carer. They said that they had suspended the carer and that they were continuing the investigation. And it's their responsibility to do that.
Yes. Well, is there any responsibility, and I take this to be something that's acknowledged in paragraph C, is there any responsibility for the Quality and Safety Commission to investigate that as well?
Yes. What I'm referring to there was when we did get the report, the investigations report, there was a mention of another care recipient who we then went back to the service and asked about, and their answer was that they didn't know who that person was. They didn't know the name of that person. So what I'm referring to there is we took that on face value. We didn't check whether there was a person, another care recipient by that name.
Yes. Is it right to say also that the Complaints Commission took on face value that the allegations were unsubstantiated? The allegations of abuse, that is?
No, we did get the report. We got the report to say that they did find that the carer had not behaved in the manner that they should have, and it was abuse, and that carer was terminated.
But prior to that, you've read Ms. Holland-Batt's statement. She says that basically occurred as a result of her going back and approaching the whistleblower and urging the whistleblower to come forward.
Yes.
But there was no action undertaken by the Complaints Commission in that regard to go and investigate the matter. It was thrown back on Ms. Holland-Batt to undertake those measures, wasn't it?
My understanding is that Ms. Holland-Batt had already raised the concerns about that carer with the service before she contacted us.
Yes.
And so their investigation was underway.
Yes.
That information about the whistleblower came later, and that was where Ms. Holland-Batt successfully encouraged that whistleblower to come forward and give information to the service.
Yes.
Is my understanding from her statement to us.
Is it fair to say that in paragraph C, what you're acknowledging is that there needed to be a greater degree of scepticism, or at least testing, of what you'd been told by approved providers?
Yes, in the case of that care recipient.
Yes.
When we got the report.
Now, in terms of Ms. Backhouse, you've said at paragraph 45 of the annexure that it appeared that her complaint took some time to resolve. It took, didn't it, over 6 months, or about over 6 months?
Yes.
Yes. And do you agree that that was an unduly slow resolution of the investigation into her complaint?
Yes.
It was only in March of 2019 that and that was some 3.5 months after she'd made the complaint, that it was given higher priority?
Yes, it went to the clinical unit for clinical advice.
That also occurred in March of 2019?
I just have to
I think
check.
on the 13th?
Yes, and it took that time frame before the advice was provided to the complaints officer.
Well, they provided their advice by the 26th of March. So they, in the scheme of things, so if you look at paragraph 36 of your annexure, you see there, you say on the 13th of March, her complaint, as it was considered a higher priority, it was reprioritised and allocated to a clinical advisor. So is that the point at which it went to a clinical advisor?
Yes.
And there, you see at paragraph 37 across the page, there's a reference to clinical advice being provided dated the 25th of March 2019. So it was only a 2-week period in which there was the advice given, that it took to get the advice from the clinical advisor. That doesn't explain the 6-month period, does it?
No, there were also delays in changing complaints officers. I thought there was a longer delay in the clinical advice coming back, so...
If you go to... And the clinical advice, you agree, went to there being problems in terms of clinical care. Do you agree with that?
Yes.
And do you see, if we now leave that paragraph and move to paragraph 46, you say there, in terms of the 6-month or so delay, there were some initial factors that gave assurance that any immediate risks were being managed. And you say that one of them was that Ms. Backhouse's mother had moved to a new service.
Yes.
That doesn't account for problems with clinical care insofar as they might affect other residents at the facility that she was at, does it?
It's hard for me to answer that because the complaints officer managing the case would have made that decision.
Well,
And the clinical unit would have had discussions, clinician would have had several discussions with the complaints officer, which is our process, to understand what's happening in the service.
Can I take you in that regard to the document that is now tab 158 of the General Tender Bundle?
Sorry, I'm just having trouble finding things.
It's on the screen.
Thank
Can you see that?
Yes.
So that's a letter from the Complaints Commissioner to what was then the Australian Aged Care Quality Agency.
Yes.
And that relates to the complaint raised by Ms. Backhouse about her mother's care. It's a type 2 referral. It raises significant issues or concerns.
Yes.
So it was serious enough for the Complaints Commission to regard it as raising significant issues. You agree with that?
Yes.
And if we go to the second page of the letter, do you see under the first group of dot points the paragraph that begins with the words, "The complainant has since removed her mother from the service"?
Yes.
Due to concerns about retribution and care delivery.
Yes.
It then says, while the concerns raised are about an individual, our review of Ms Backhouse's mother's care records indicates there may be potential to affect other residents.
Yes.
So
That's why we made the referral.
yes. And towards the bottom of the page, under the dot points, you see it says, since 1 January 2018, we've received 3 complaints in relation to the service, one with similar issues of continence care and falls management.
Yes.
So these were issues that went well beyond Ms Backhouse's mother, weren't they?
Yes.
So going back to what you say in paragraph 46 of your annexure and subparagraph B, it's neither here nor there, is it, that Ms Backhouse's mother had moved to a new service? That wouldn't affect the immediacy of the need to deal with the complaint in respect of deficiencies in care at the facility?
No.
And you see at paragraph C, you say a type 2 referral was made to the Quality Agency on 19 December.
Yes.
That's the letter that we just went to, isn't it?
Yes.
That was the letter. That letter was sent on the 19th of December. But you have said yourself in paragraph 49 that there was a divergence between the Quality Agency's assessment of the adequacy of care and the Complaints Commission's assessment of the adequacy of care. They didn't
Yes.
regard it as warranting further attention, but clearly the Complaints Commission did.
That's right. The complaints officer in the clinical unit had a lot more information. The information they had were individual clinical records in relation to Mrs Whiteman. They had hospital records. They had a lot more information that the quality assessors didn't have when they did that first assessment. And so that's why we did the type 2, so that they then understood that we had found out this information via our clinical assessment.
But they, even after that type 2 referral, didn't assess the risk in the same way that the Complaints Commission did they? For instance, at paragraph 32 of your statement, the annexure, pardon me, you actually say, in response to receiving the referral, the Quality Agency assessors conducted an unannounced site visit, and there are 2 things that they observed. Staff reported they had sufficient time to care for consumers. Care recipients interviewed were satisfied.
Yes. I'd just like to check. I think they did 2 visits.
Oh, pardon me. Are you referring to the later referral? Sorry, pardon me, Ms Reid. So at paragraph 48, you refer to a supplementary referral that was made?
Yes. Yes.
Is it fair, though, to say that between what is now the Quality Assessment and Monitoring Group and the Complaints Resolution Group, there is a difference of opinion about the seriousness of the departure from good quality care at this facility?
By the time this supplementary referral was made, the service had already reported all of the changes and what they were doing to mitigate what we'd found and fix up what we'd found, and we did find the service lacking in a number of areas, as you know, and the service had described an action plan and a whole lot of other areas that they agreed to make sure that their care had improved, particularly clinical care, and that was quality assured by the clinical unit.
Can I just, seeing as you raised the clinical unit, I mentioned earlier that there was a allocation to a clinical advisor on the 13th of March 2019 in Ms Backhouse's complaint, and that the clinical advisor gave advice dated the 25th of March 2019. Do you recall that?
Yeah.
It's brought to my attention that you've also referred to the fact of the complaints officer seeking advice from the clinical unit in December the previous year. You say that at paragraph 29 of your statement. But in terms of the advice that was received from the clinical advisor, I take it that took 2 weeks from when it was referred to the clinical advisor, is that right? In that 6-month period.
Yes.
Okay, now in terms of the process, you've no doubt seen what Ms Holland-Batt has said about how her case was referred to early resolution, and you've referred to that referral taking place the day after she made the phone call to make her complaint. Perhaps if you have a look in the annexure at paragraph 4.
Thank you.
You see there, on the 4th of April 2017, it was determined that this complaint was a suitable case for early resolution.
Yes.
So within 1 day of making the complaint, it's determined that this case ought to be dealt with more summarily. Do you agree?
Well, it was determined that it could be dealt with at early resolution, yes.
And Ms Holland-Batt wasn't consulted about that determination, was she?
No.
And do you agree that she ought to have had some input into how the complaint might be resolved?
There is a file note that the complaints officer did verbally discuss, have several discussions with Ms Holland-Batt about her issues that she wanted us to resolve and the outcomes she was looking for, and part of that file note was that we would be going back to the service and discussing her outcomes with them, and that we would be... So I guess what I'm saying is that Ms Holland-Batt knew that what we were going to be doing was going and phoning the service, which is our early resolution approach.
She didn't know, though, that there were other options for how you might deal with it, that there was an early resolution approach and then there was another approach involving referral to the resolution team, did she?
Not to my knowledge, no.
And do you think that people should be told that there are those different methodologies for resolution of their complaints at the outset?
Yes, I do.
And do you think they should have an opportunity to make some sort of submission as to which of those approaches they would prefer?
No.
You don't think they should have some opportunity even just to make a submission to that end?
They could say, but it really is... the decision is up to the delegate and the complaints officer based on how the case is going, what the factors are, what the risk factors are, the complexity of the case. The complaints officer and the complaints manager determine the process that's needed. If it goes to resolution, there is a there is a discussion with the complainant about some of the tools that we use, and one might be conciliation. In that case, we would discuss with the complainant, we would like to conciliate on site, would you be open to that, and describe the process. So depending on what stage of the process we're at, there is information provided to the complainant.
But you wouldn't be telling somebody that their complaint has been referred to early resolution?
Not early resolution, but we do advise them if it goes to resolution.
And so when a complaint goes to early resolution, you agree that that document that I took you to earlier about how matters are to be resolved by early resolution states our intent is to resolve a case quickly if it's been referred to early resolution. Do you think somebody should know about that the intent of the decision maker is to resolve the matter quickly if it's referred to early resolution?
I think the complaints officer would have said, because that's our process, that we will try to resolve this as quickly as we can. We'll try to get the outcomes for you as quickly as we can. I mean, that would be the language that we would use, because we believe that if we can resolve it quickly with the service and with it's better for relationships, it's better for outcomes at the end of the day.
In relation to the process that then followed, you will have seen that Ms Hollenbat indicated that she was never shown any written response from the approved provider.
Yes.
Now, she has an interest in the process, obviously. The key interest is the complainant. Do you agree with that?
Yes.
And do you agree that due process in those circumstances ought to include provision of a written response from the approved provider to her for her comment?
What happens at early resolution is that if the complainant says they're really satisfied and they're happy, our process is to ask the complainant, would you like a feedback letter or would you like more information? And depending on what they say, we will pursue that for them.
Well, my question was, do you think that the appropriate course was to give her the approved provider's response?
Listening to Ms Hollenbat's evidence, yes. I think the communication needed clarifying, not verbally but in writing.
Provision of that document, certainly in this case at the very least, would promote transparency of the process, wouldn't it?
Yes.
And it would give her proper and fair process to deal with anything that was put by the approved provider with which she disagreed.
Yes, and I think it would have given her a greater understanding of the outcomes that we'd achieved with the service for her.
And possibly a greater satisfaction with the process.
Yes, yes.
Now, you referred, I took you earlier to the question of testing information provided by an approved provider. Do you remember how that was one of the shortcomings that you identified in paragraph 18 of the annexure?
For Ms Hollenbat?
Yes.
Yes.
Other than speaking with management, what inquiries were made to test the assertions in the approved provider's response?
The only evidence that we collected, to my knowledge, was a copy of the report.
A copy of which report?
The investigation report that the provider undertook into the investigation of the carer.
That's the document that was provided by management at the approved provider?
Yes, and then the responses from management, which you're talking about, the provider response.
So nothing else?
No. It was all verbal and discussions over the phone.
But there were no interviews with staff or residents or anyone else other than Ms Hollenbat?
No, because the provider did that with their investigation. They interviewed 11 people.
So you relied on the provider's conduct of the investigation yourself?
Yes.
When I say yourself, I mean...
Yes, the complaints officer did.
The complaints commissioner relied on the provider to conduct the investigation?
The complaints officer did, yes, and the complaints manager.
Do you regard that as satisfactory?
We rely on, now, it might be seen as unsatisfactory. We don't follow up. We do rely on the complainant coming back to us and letting us know if the changes have actually been put in place. Our other reliance is the strengthening joined up now of ourselves and the Quality and Monitoring Group, where we make many more Type 1 referrals at the end of our processes so that they're able to monitor and check that what the services say they have put in place has actually been put in place.
Well, that was my next question, actually. How was that done in the case of this service, Ms Holland-Batts, that was the subject of Ms Holland-Batts' complaint? Do you know if there was any follow-up on the purported improvements that have been put in place by the approved provider?
No, the complaints officer didn't make a Type 1 referral at the end of the process.
So there was no follow-up to see that what had satisfied, at least in words, the complaints officer had actually been put into effect and was sustainable down the track?
No, unless the complainant came back, and to my knowledge she didn't.
Well, she wouldn't, because her mother had moved to another facility.
That's right. Yep.
So, was it the same in the case of Ms Backhouse's complaint? Was there an absence of a Type 1 referral after that?
No, we made the referral that you showed me, the supplementary referral at the end.
Oh, pardon me. Sorry. Sorry,
That's
Ms.
okay.
Oh, pardon me. Yes. Yes, oh, pardon me. Yes. I've just been informed. I think I've got the two cases conflated in the sense that Ms Holland-Batts' father didn't move to another residence, so I apologise, Commissioners, for that. But
it's Mrs Whiteman.
Yes. So in the case of Ms Backhouse's complaint about her mother,
yes,
was there a Type 1 referral that followed on from that?
In the case of Ms Backhouse's mother, there was a referral made at the end of the a supplementary referral made at the end of the process, yes, to provide the Quality Monitoring Group with the outcomes that we'd found, where we'd found that care was lacking, but we also informed them of the remediation and improvements and actions the service had taken in the form of the action plan.
But no such referral in respect of Ms Holland-Batts'
Correct.
complaint. Yes, that was cast back on her. If she was going to, if there was a need for a further complaint, it had to come from her or some other resident or their representative. In
that instance, yes, we could have received further complaints as well.
Yes. In terms of Ms Holland-Batts, can I take you to what is now tab 157 of the General Tender Bundle? And it's document number CTH.4009.998.0003. While that's being brought up, perhaps this complaint was resolved on the basis that all issues had been resolved to the satisfaction of the complainant.
Yes.
Yes. And you've heard Ms Holland-Batts' evidence about that.
Yes.
Do you think that she was satisfied as to how the issues were resolved in truth?
No.
Yes. And in terms of this page, this document that's been brought up, if we can go to the second last page. And you see at the bottom of the page there's a passage that begins with COM remains sceptical of improvements and is concerned by the procedures that the procedures discussed were in place at the time but didn't prevent her dad from being victimised.
Yes.
However, she's agreed to finalise the complaint. Do you agree that doesn't suggest that she was satisfied with the process, even to the complaints officer's knowledge?
Well, Ms Hollenbat asked us to go back to the service and find out from the service what procedures they had in place and what whistleblowing procedures and other processes they had in place, which we did communicate to Ms Hollenbat, or the complaints officer did communicate to Ms Hollenbat. So there's kind of a piece there that's missing which is elsewhere, where the file note would have said that she verbally explained the outcomes and what the service provider had said and agreed.
But accepting all of that, do you agree that even after that explanation's been given, there's an ongoing level of concern on the part of the complainant at that point?
I'm sorry, I don't know, because the complaints officer had other file notes, and she, in my view, she 100% thought that Ms Hollenbat was satisfied. I know now, listening to Ms Hollenbat's evidence, that she wasn't.
Do you think in cases such as these there is a impetus to deal with the complaint quickly at the expense of a proper due process for the complainants?
No.
No further questions for Ms Reid. Thank you, Commissioners.
Ms Reid, I just want to confirm with you my understanding of the way in which the early resolution of complaints is achieved. Your organisation gets a written complaint or a telephone complaint, which is reduced to writing, so that there's a record of that complaint. Yes. And what's the next step? Is it that the terms of the complaint is then sent to the provider?
Yes. The next step is to put those allegations or put those concerns to the provider, and then to immediately start to talk to the provider about what they think they could do to meet the outcomes. We also explain to the provider the outcomes that the complainant is looking for.
Yes, and so there is both written communications and telephone communications between your office and the provider.
Yes.
Is that right?
Yes.
What's the next step? The provider responds in writing?
Yes. To our questions, yes.
Yes. And at that point, does the case officer make a judgment about whether the complaint has been satisfactorily resolved or not?
The complaints officer, yes, makes a judgment, yes.
And once the case officer has formed that judgment, if it is favourable to the provider, that's an end of the matter, is that right?
No. Once the complaints officer has thought about that, they then call the complainant back and discuss what the provider has proposed, what the provider has proposed to do to improve care or to meet the outcomes that the complainant is looking for. Sometimes an apology, sometimes both that and what they're going to do to remediate or fix up these areas of concern.
And that's done over the telephone?
Yes.
And if the complainant says, well, I'm satisfied with that explanation, that's an end of the matter?
Yes.
If the complainant says, I'm not satisfied because of A, B and C, what happens then?
What happens then is that we take the A, B and C back to the provider as well and discuss again A, B and C and keep going back until the complainant is satisfied that the provider has improved. If we get to a point that we think that the provider has, and the complaints officer can make that judgment, has put all the necessary steps in place to mitigate risk, to improve care, then it's to the satisfaction of the Commissioner, and it's closed to the satisfaction of the Commissioner. The complainant then has review rights.
Yes. What exactly are those review rights?
They're able to come back to us within a certain number of days and ask for a reconsideration of their decision.
And who conducts that review?
There's a review team, so it's a separate officers that report to me, not the National Complaints Manager.
Were you here this morning when Ms Barnes gave her evidence?
Yes.
And you heard her saying that she was simply advised by letter at the end of the review process that it had been decided not to investigate the matter further, but given no reasons beyond that or other explanation. Now, I'm conscious that that's probably the first time you heard that.
Yes,
but is that a normal response? And if so, do you regard it as satisfactory?
It's not a normal response. The response would have a bit more information in it, and it would also say that you're able to go to the Ombudsman if you're not happy with, and we give the details, phone numbers of the Commonwealth Ombudsman to be able to take that further if they didn't agree. Sometimes we would also do another whole resolution process. It's not
in the normal
there.
course of an investigation, would the case officer provide a copy of any written response from the provider to the complainant?
If the case goes to resolution, which is where we are able to use investigation, conciliation, mediation or another more intense service provider resolution, the complainant always gets a written response, and yes, they do get a lot more information. We will always ask the provider, can we give that response to the complainant? It's a lot more intensive and they do get a lot more information.
How can a complainant make an informed judgment as to whether or not the matters under complaint have been satisfactorily resolved if they don't have access to the precise response of the provider?
So if you're referring to the early resolution where it is our process to verbally provide that information, and most of the time people are satisfied and they talk through the issues and they say, I'm satisfied.
It depends on what they're told, doesn't it?
Yes.
And the case officer might be paraphrasing or shortcutting. Why not just put the response on the photocopier and scan it and send it?
Okay. So we can ask the service provider. The service provider can say no.
Why?
Yes.
The complainant's written complaint is given to the provider. Why not reciprocity? In aged care, I would have to say that it's not an open and transparent complaints management kind of best practice, if you like, within services generally. They are a bit defensive and feel threatened by doing that sometimes, and that's about open disclosure. With the new standards, we believe that's going to go a long way to trying to help to change that culture within aged care services.
that they are open about their complaints. They do talk about their complaints, such as Professor Patterson talked about in his evidence. So under the Aged Care Act, we are unable to give that document to a complainant if the provider doesn't agree due to those provisions.
On a different topic, I'm just trying to get a clear understanding of how there are internal communications and notifications from one section of your operation to another about the existence of problems.
Yes.
You were familiar with the Earlhaven matter?
Generally, yes.
Well, you would know that in June the assessors had gone in, and amongst the things they were told was that 71% of the residents of the establishment were on some form of psychotropic medication, and 50% were subject on a regular basis to physical restraint. Now, that was information gleaned from the providers, so that there was no question of needing to put that information to the provider to get it confirmed. That's what the assessors had been told.
Yeah.
Now, as we were told yesterday, that should have raised alarm bells. Do you know what happened internally within the agency, or the commission as it now is, about whether that information was conveyed to those elements that could do something about it? I would have thought there should have been a clinical team down there the next day.
Yes, Professor Patterson talked about the canary in the coal mine, and that complaints have that power and that information and that intelligence. And unfortunately, as you saw through some of the evidence given, that information, the complaints officer should have joined the dots, and the complaints manager joined the dots and passed that information on to the quality monitoring group a lot quicker than they did. I would agree.
Well, they hadn't done it by the 11th of July, and as far as we know, it's not been done since.
Oh, they have it now, yes.
Well,
yes. But you're right.
Beyond any point at which they can do anything practical about it.
Yeah. Yeah. They didn't do their curiosity.
I just have one question, Kate.
Yes.
In the new procedures, is it a requirement when an individual makes a complaint to a provider, so before it comes to you, that the provider now makes the response in writing?
There's no requirement for them to previously manage their complaints, except to have good complaints management processes in place. Now with Standard 6, there are some really more effective requirements, in my view, that service providers are going to have to meet, and they're going to have to show evidence that they have open disclosure in place, that they have better practice complaints management processes in place, that they are recording those, and that they are showing that their complaints make improvements. So they're going to need to show the assessors that when they're assessed now under Standard 6, and also with clinical open disclosure in the clinical standard. And that's a good thing.
Anything arising out of that, Mr. Knight?
Just one question, and that is this, Ms. Reid. In terms of what you say prevents approved providers from providing, prevents the Quality and Safety Commission from providing the approved provider's submission to complainants, what statutory provision is that?
I don't have the Act with me now, but it's words to the effect of not sharing information about the provider's business. It's under the Aged Care Act. If I had it, I could look it up and find it, but yes. That's if they say no. There are occasions where they say yes as well.
Are they asked routinely as to whether or not any written submission that they've put in can be shared with a complainant?
I believe so, yes, but not in the case of Ms Hollandbat, unfortunately.
Nothing further. Thank you, Commissioners.
Ms Reid, you might be kind enough to add the answer to that matter to the other item which you volunteered very kindly earlier to provide the Commission with information about. But subject to that, you're excused from further attendance. Thank you very much for your evidence.
Thank you very
much. The Commission will adjourn until 12 noon.
I'll stand. The Royal Commission is now adjourned until 12 o'clock noon today. Silence, all stand.
Do we stand?
Before you start, Mr Bolster, I've just got to amend the exhibit list. The last two exhibits in order should have been marked as 8-39 and 840. Yes, Mr Bolster.
Thank you, Commissioners. The next witness is Professor Deborah Margaret Paconi, who I call, and who is on the audio visual link from Sydney. Perhaps if
Repeat after me. I swear by Almighty God.
I swear by Almighty God
that the evidence I shall give.
That the evidence I shall give
will be the truth.
Will be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
If the following document could be brought up, WIT 0290 0001 0001. Professor Paconi, you have in front of you a hard copy of a document that bears those numbers at the top right-hand corner. Is that correct?
I'm just trying to check now.
But she's got a statement.
I have my... Mr Bolster, I have my statement in front of me.
Yes. Does it have...
The witness statement.
Does it have some numbers at the top right-hand corner?
No, this particular one does not.
All right. It's the statement dated the 19th of July this year?
Yes.
And it comprises some 39 pages?
Yes, that's correct.
Is that statement true and correct to the best of your knowledge and belief?
Yes, it is.
I tender Professor Paconi's statement, Commissioner.
Yes, the witness statement of Deborah Margaret Paconi dated the 19th of July 2019 will be Exhibit 8-41.
Professor Paconi, you are the Chief Executive Officer of the Australian Commission on Safety and Quality in Healthcare, correct?
Yes.
And you've held that position since 2012?
Yes, that's correct.
So far, this Royal Commission has heard evidence from various officers in the Safety and Quality Commission in relation to aged care and the Safeguarding and Quality Commission in relation to the NDIS. What's the distinguishing feature of your commission?
Our commission is a statutory health corporation established under the health reform legislation to oversee, this is a précis, to oversee the safety and quality of the healthcare, the acute healthcare system. It's different to the other agencies in that it's a shareholder model between the Commonwealth, the states and the territories actually constitute the group that we report to.
And where does direction in relation to the development of standards come from? Does it come from COAG or does it come from the organisation itself?
It comes generally from the organisation. From time to time, COAG will make referrals back to us to investigate matters and provide advice to them.
You say in paragraph 15, if we could perhaps turn to that, you list there the purposes of the organisation. Could you speak briefly to what it is that you're principally focused on in your activities?
The Commission has been established to lead and coordinate national improvements in safety and quality in healthcare. We focus most heavily on the formulation of standards, guidelines and other matters relating to safety, and also to the operation of an accreditation system for hospitals, day procedure centres and dentistry.
So you accredit all public hospitals and private hospitals?
We oversee and that accreditation system, yes.
All right. And the assessors who are involved in that accreditation system, do they respond to a training framework that you develop and you control?
They're required to respond, yes.
What about assessment against the standards, which we'll come to in due course? Who carries out the assessment process?
There are 8 independent accreditation agencies that have been accredited by the Commission for the purposes of conducting accreditation of both the public and private healthcare system. And so it will depend on who's been appointed by that health service to conduct the accreditation. It generally is done on a tender process.
Is the approach that the accreditation procedures and the people who do it operate to a national framework and national principles?
Yes, they must operate to our framework and principles.
All right, we'll come back to that a little bit later. But can we talk firstly about transparency and public disclosure of performance information? That's one of the issues you deal with fairly early in your statement. Why is the measurement of clinical data fundamental to advancing safety and quality?
Because it actually shines a light on what is actually happening. There's very strong evidence that promoting that transparency will also inform the choice of the consumer by providing them with direct information. It certainly stimulates improvements in quality and safety, and it also holds the provider accountable for the delivery of health services.
Could you speak briefly to some of the best practice models in that area around the world?
I would have to say that Australia is lagging behind some international examples. So, for example, in the United Kingdom, there's a national adult cardiac surgery audit that's publicly reported annually and actually gives you the results and outcomes of cardiac surgery. So that means that I, as a consumer, can look that up and decide which hospital is going to give me better outcomes. We're currently working through a process with the Australian Health Ministers Advisory Council and the Council itself on improving measures and to develop a set of measures that are relevant to the consumer rather than a set of performance measures.
We'll address that in some detail later. How broad, though, is the system of mandatory reporting in Australia?
The system of mandatory reporting of adverse events is very broad and, in my view, one of the best developed internationally. So every hospital, public and private, is required to report on a set of what are called sentinel events, which are events that should never happen, very serious adverse events, and then a series of other clinical adverse events, and then more recently a series of what are called hospital-acquired complications. So we have a very detailed reporting system on adverse events.
All right. Well, what does your commission do with the information that it receives at all three levels?
The sentinel events are reported annually through the Ministers' Council. There's not a large number. There's about 67, but they're very serious. You know, for example, wrong-sided surgery, a mismatched blood transfusion. These are things that should never happen, and they are publicly reported by each state and territory. The other data is reported by each jurisdiction, so the number of clinical events and incidents by hospital, and then more recently the hospital-acquired complications moving into a reporting regime where they'll be reported on a hospital basis.
Well, if we could look at the hospital-acquired events, or HACs as they're called, you list them in paragraph 36. If we could perhaps bring that up onto the screen here at the Commission. A through P are the hospital-acquired complications. Is that you have a copy of that in front of you, don't you, Professor Paconi?
Yes, I do.
Yeah, that is. You say they include. How many HACs are there in total?
There are 10.
Why do we see A through P if there are 10?
Because some of them break into subcategories, and there's been a recent addition. So we've given you the most recent list there is 16.
Right. And so what's the process for the reporting of those on a hospital by hospital basis? How does that information come to you?
The information is required to be reported, and this requirement was made by the Health Minister's Council. The information is sourced from the patient's medical record. So we know, and we have a lot of confidence in the actual accuracy. The information is then fed up through that hospital, through the State Department of Health, and then into us at the Commission.
So if you wanted to know if there was a trend in relation to pressure injuries in a particular region of New South Wales, for example, you could analyse the data from the previous year. Is that a fair summary?
Yes, it is.
If you were able to identify an increase in a particular clinical indicator such as that, what would be the response of the Commission?
It's now actually subjected to a funding arrangement. So if the hospital has a higher than accepted rate, say, of pressure injuries, they will actually lose funding based on that.
When you look at that list, a good number of those indicators could transport or be applicable directly to a funding situation in aged care, couldn't they? I'm thinking,
absolutely.
I'm thinking, for example, of delirium, malnutrition, infections, and of course pressure injuries themselves.
Yeah, absolutely, and I would add falls resulting in fractures as well.
What about UTIs?
They'll get picked up in the healthcare associated infections.
Right. So that
urinary tract infection is the most one of the most common infections in residential aged care.
I mean, what are the barriers for a hospital to implement a system that records these sorts of complications?
There's no barrier.
Would there be a barrier for an aged care facility to collect and report on information about a select group directly applicable to aged care?
No, in my view, no barrier.
The tying of these events or performance measured against these events at all three levels, how significant has that been in achieving a clinical performance?
If we go to the actual performance reporting data, which has been reported for a long time, and you may be familiar with things such as hospital waiting lists, waiting times in emergency departments, they have been very significant in the way the actual health system is measured, because the community doesn't find it acceptable that a person waits too long for a surgery, particularly if a surgery is for a cancer surgery and the doctor has said they need it within the month and they're waiting 3 months. This is not acceptable. So those performance measures that have led to very significant changes in the system. These more recent measures, which we've had out now for just under 18 months, getting on to 2 years, it's early days yet, but we're already starting to show some reductions in some of those areas. But in international jurisdictions that have used them, some of those complications have dropped by up to 40%.
Yeah. So at the moment we're talking about disclosure, reporting and analysis within the healthcare system. So this would be information known to the hospitals, to practitioners, to the state departments of health. What about if we go outside that bubble to the consumer, the patient, or the relative of the patient? To what extent is there public disclosure and reporting of similar data?
So, in our view, very little. Yet, we have very, very rich sources of clinical outcome data that would be of great interest to the public, but they're not aware that these data exist, and some of the medical profession aren't keen for it to be published. So there are clinical registry data going back over 10 years that show you the outcomes, either good or bad, from different interventions. But we do know that people are not so much interested in performance, though they're very concerned if their local hospital has ambulances queuing, you know, out the front. But they tend to be more interested in what's happening for obvious reasons to them. So they'll be interested in things like what is the cost of care, including out-of-pocket expenses. How long are they expected to wait for an elective procedure? How long will I be in hospital for? Will someone give me decision aids to help me make the decision about the treatment options? What's the likely success of treatment outcomes? People are increasingly interested in the hospital infection rate because of the emergence of antimicrobial resistance. And they're very interested in the opinion of other patients about their outcomes and experiences of care.
Is there any reporting at all in the aged care system that you're aware of about the infection issue that you were just talking about?
There is no reporting, and in fact, the Commission has worked with other agencies in the last 2 years to do reporting on infection rates in aged care facilities.
Should that be a priority matter?
Yes, it should.
Why?
It's a major public safety risk, and it's a major risk to the actual individuals within the residential aged care facility, and even more so because of antimicrobial resistance.
For example, where there's a gastric outbreak in a nursing home, it could be a fundamental, critical incident that requires some serious response. Are we in the same ballpark in terms of reporting? If there was reporting about infection control in that facility, would that not assist in stopping those sorts of outbreaks?
Yes, it would. Though I do believe that we are better at public health responses to things like, for example, listeria, gastro outbreaks and other things than we are to urinary tract infections, you know, major skin infections and other areas.
All right. You mentioned that only 7 indicators are currently reported out of, I think, an intended list of 17, which is the ultimate aim. What progress is underway to get to 17, and when is the health system likely to get there?
We actually report all of these now.
Right.
So starting July 1, every one of these hospital-acquired complications is reported by every public hospital and day procedure centre in Australia.
You mentioned one of the problems in getting to that point has been the fact that different jurisdictions collect different data in different ways. Is that correct?
That is absolutely correct. So one of the roles of the Commission is to harmonise those data collections and to remove some of that controversy. So for argument's sake, one jurisdiction held us up for nearly 4 years over a denominator.
Yeah.
Sad but true.
Well, in aged care, where there's one funder, one regulator and one person to collect the data, those barriers wouldn't be there.
Absolutely.
All right.
It's a much easier data collection exercise because of that.
Can we go back then to the patient-centred reporting measures? They're called PROMs and PREMs. A PROM is a patient-reported outcome measure, and a PREM is a patient-reported experience measure. What's the difference between the two?
The PROM is geared more into the actual procedure. So it might be a person undergoing treatment for cancer. They might have had a hip replacement. The PROM's reporting tends to go into some detail. So, for example, if I decide to have a knee replacement, it will tell me all the things I need to know. How long will I be in hospital? What day should I be up walking around? The average person's going to be up walking around. What will my pain be like? But most importantly to the individual, what will my exercise tolerance and pain be like 2 months post-surgery? So the PROMs tends to focus in on clinical groups, whereas the PREMs, which were developed by the Commission, focus in on the person's experience in the healthcare system.
Right. I want to turn then to the issue of standard setting, and one of the roles of your organisation is the development of the 8 standards in the national health standards. What is the philosophy behind the standards for the health sector?
The standards are designed to protect the public from harm. So they're a risk mitigation strategy and to improve the quality of the healthcare system.
And how closely are they aligned to the aged care quality standards?
While I am familiar with the aged care quality standards, I don't know them in depth, but I do know that there are some, and I'm taking this very much from memory, that there are some crossovers, such as clinical governance, which we have been involved with, partnering with consumers. They have an infection standard, and I don't recall if they have a medication safety standard.
All right. You talk about an aged care module. Is that what is that? Is that a part of the standards, or is that a clinical governance, a clinical guidance standard that operates outside of the rest of the standards?
This arose because there are health centres called multi-purpose centres. They're generally in rural and remote settings. They have a mixture of long-term residential care, which is the majority of the care that goes on there, some acute care given via generally general practitioner or nurse practitioner, and then allied health care. Those services approached us and wanted to be accredited under the national safety standards. So we have to date accredited 147 multi-purpose centres under the national safety standards.
And do they report to you on the aged care side of their performance?
Yes, they do. And that the purpose of developing that aged care module was we do this with the standards. If we've got specialised services, we take the core standards but write it in such a way that it's relevant to that particular service, so it becomes more real for them and also for the consumer.
So, for example, the hacks, going back to the list in paragraph 36, that are applicable to aged care, you receive data from the MPS about how they perform in that regard?
No, we don't, because they're residential. They're listed as residential aged care beds, but we have actually studied it, and we're giving this some consideration at the moment because there are in some places quite high rates of pressure injuries, infection and other areas, surprisingly high rates, and more than we see in some acute care hospitals.
Right, so,
but the answer to your question is they can. We could turn that on tomorrow if we wanted to.
Okay. Thank you. What aspects of the health standards would you like to see as a priority in the aged care standards? Have you thought about what's missing? What essential features in the health standards could be transported into aged care?
Yes, our view is there should be one set of core standards, because it doesn't matter where an older person is, whether they're in doctors' rooms, they're at their general practice, community health, residential aged care, or an acute care setting. It's the same person with the same set of care needs. So we've argued fairly strongly in our submission to the Royal Commission that there should be a set of core standards, and I'm just trying to take myself to where we actually put this in our submission. Yes, so we felt for governance, including clinical governance, patient-centred care, preventing and controlling healthcare associated infection, comprehensive care, so pressure injury, falls, poor nutrition and malnutrition, cognitive impairment, particularly in relation to unpredictable behaviour and restrictive practice, the actual accreditation scheme itself, and then risks of harm for older people at times of transition, then medication safety, end-of-life care, and having a series of safety and quality measures.
I just wanted to explore...
We believe they should be harmonised. They should be exactly the same, whether it's an acute care setting or in a longer-term care setting.
I just wanted to explore with you one of those standards, and if we could perhaps bring up in the Commission hearing room tab 8, which is the health standard, and we'll go to page 138 of that 138 of that document to standard 111 and 112.
So this is incident management systems and open disclosure.
Yes. So if I don't have that screen in front of me, if I could have that brought up. Yes, 111 and 112. I do have that now. Thank you. And if we could have brought up side by side with that the relevant aged care standard, and the aged care standards are at we should have those. Perhaps I'll just read them out. In the aged care standard 8, it's in these terms: where clinical care is provided, a clinical governance framework, including open disclosure, is a requirement, but it's expressed in those very simple terms. At standard 6, there is a requirement that appropriate action is taken in response to complaints, and an open disclosure process is used when things go wrong. May I suggest, Professor Paconi, that there is far more detail in your standards 111 and 112. Can I ask why you go into such detail in those standards?
Yes, so the open disclosure system has been in place in Australia for over 10 years, and in fact Australia was the first country to adopt this as a national standard. So we now have a lot of experience with the actual operation of it in the field, and it's over the years been quite variable. So given that, when we revised these standards just recently, we made the elements of it much clearer in this second standard, but it's also the standard that I often refer to as the Sergeant Schultz defence, which is when something goes wrong, suddenly everybody knows nothing, or can't remember anything, or didn't see anything. And I do a lot of reviews of, lapses in safety or failures in safety, and there are always two elements in those reviews. One is a failure to do open disclosure with the people involved, and the second one is the failure to give informed consent. It's a feature in every single one of them.
So how long has open disclosure been a requirement under the national health standards?
10 years.
And how difficult is it to entrench it in a health organisation, such as a public hospital?
Initially, in the earlier days of it, I thought it was quite difficult. It was a major change in culture. Let me say this, though, that the best clinician will always tell the patient and the family when something goes wrong. It's just an automatic response. But there are a number of people who, for whatever reason, have chosen not to do that. My observation is, over the last couple of years, that this system of open disclosure is now just operating automatically. But there are times when it doesn't operate automatically, and that is generally times when you are having a major failure in the safety of the system.
How do you measure that someone is implementing open disclosure? Is there a reporting of events and some form of tracking of how the process is implemented on a case-by-case basis?
Yes, there is. So usually the event has to be reasonably significant, resulting in harm to a person. And so as a part of that procedure of investigating that incident, open disclosure is compulsory. So then it's recorded at that time that a conversation was held with the person, an explanation was given that something had gone wrong, that had resulted in harm, an apology is given, and we often also try to explain to people how we're planning to prevent that from happening in the future.
All right. The other standard that I wanted, the other health standard that I wanted to draw to your attention was standards 1.8 and 1.9 regarding measurement and quality improvement. You have a copy of those in front of you, don't you?
And these are the national safety standards?
Yes. And if we could go to those standards, it should be in the same document as we were looking at before. It should be page 138 in tab 8.
Oh, yes. So these are patient safety and quality systems. Yes.
I won't take you to the aged care standards, but what's the reason for going into that degree of detail for those standards in health?
For exactly the same reason, Australia has led internationally in having incident reporting systems that are mandated, that are required. When something goes wrong, people are required to report that. And so we wanted to provide the actual detail in the standard to make that clearer. The reason we need this incident information is frequently it provides an early warning sign that something is going wrong. You know, if the same problem occurs again and again, the same sort of medication error, or suddenly the pressure injury, not suddenly, but over time, the pressure injury rate is increasing, or our infection rates are increasing, this provides early warning signs to step in and to remediate the problem. So it's the most detailed intelligence that we get into the system about patient safety.
Right, thank you. In paragraphs 133 through to about 137, you deal with the way in which you identify issues in accreditation and assessment processes. Could you speak very briefly as to what it is that any organisation that deals with those two tasks, accreditation and assessment, needs to focus on?
We have this very tightly detailed. So if a hospital is going through a survey, the purpose of the survey is to ensure the community that they have implemented the national safety standards and that they are operational in that hospital. So a team of experts ranging from medical clinicians, nurses, senior management people, and increasingly consumer representatives are put together, and then they go into the health facility and examine it in detail for those matters.
How important is it that you have a community representative in that process?
It's very important because that person brings that patient-centred perspective, which is critical.
All right. Sorry if I interrupted. If you could just continue.
No, that was.
Okay.
I think I've lost it.
No. Well, let's get back on track. Where does the assessment process fall down? What errors do you see creeping into the assessment process that you have to constantly look for and you constantly have to address?
Yes, so there are there were major significant issues with the actual survey process. So this was raised with the Commission by state health departments, chief executive officers and other people, that the actual reliability of our survey process needed some significant improvement. It came to our attention most when a hospital that had a series of unavoidable deaths of neonates received a 3-year accreditation. It happened at that time I was assisting in the investigation into those matters, and I couldn't see how they possibly could have passed the governance standard. So at that time, and for some time, we'd had a view that we needed to improve the veracity of the system. So we implemented a series of improvements that commenced from January this year to improve the reliability and veracity of the survey process.
That leads me to one of the last things I want to deal with, and that is the governance issue and clinical attestation. To what extent do the standards require that the people with decision-making control in the hospital or in the health system to attest to the services that the facility aims to provide under the standards?
This is mandated. It is compulsory. It has been one of our observations that often when there have been failures, that the boards will tell you they had no idea that these problems were going on, which quite frankly I don't accept on any of the times I've been told that. So we wanted to make safety and quality as important as finance and as general performance. So we now require each member of the governing body to sign an attestation statement to say that they're satisfied that a whole range of issues are in place for safety and quality.
And how accountable are they for that attestation?
If they were to give or mislead in any way in that attestation statement, which is very detailed, there would be significant response from the regulator.
Such as?
my view would be they would be removed from their position, and depending on the seriousness of it, there'd be further investigations.
All right. Unfortunately, Professor Paconi, we're coming close to the end of the time available, but can I ask you this? Transparency has been a theme of the hearing this week, transparency of regulation, transparency of responses to complaints. What's the most significant thing that the Commission needs to understand about achieving or attempting to achieve or aiming to achieve transparency in this field?
That transparency is absolutely critical to the operation of the system and to the accountability that we give to members of the community, that these care facilities are doing what they're meant to be doing. We have to have it. You will come against a lot of pushback. People will tell you that it's impossible, that it's adding another regulatory burden. Why are you doing this? They will give you every reason not to publicly report. This is all absolute abject nonsense. It is in the public interest that these matters are reported on a regular basis, that they're located somewhere that I, as a citizen, can go to and I can look it up.
Those are my questions. Thank you, Commissioners.
Professor Paconi, thank you very much for your evidence. We are grappling with the concept of disclosure and proper regulation of facilities for the elderly in this country, and going back to first principles, it's very hard to discriminate as a matter of principle between what's going on in the hospital system and what's going on in the aged care system. So your evidence is invaluable, and we're very grateful to you for taking the time to come and give it to us. Thank you very much.
Thank you, Commissioner.
Nothing for this witness.
Oh, I'm sorry. Unbeknown to you, Counsel Rose behind the screen.
Might the witness be excused?
We break the link.
Yes. Thank you, Professor Paconi.
Thank you, Mr. Barstow.
There was one other thing that I wanted to deal with arising from that evidence, Commissioners. There is an open disclosure framework and guidance published by the Aged Care Quality and Safety Commission that's so far not in evidence. It seems to have been published in advance of the standards coming into effect on the 1st of July. If it could be brought up, it's RCD 999 0173 0001. And I tender it.
I'm happy for that to occur as soon as I see it.
Yes, I want to see it too. It's only just been added to the... That's it.
Right, so does the document bear a date?
No, it doesn't.
All right. The document entitled Open Disclosure Framework and Guidance, produced by the Aged Care Quality and Safety Commission, will be Exhibit 8-42.
Thank you, Commissioners.
Now, Mr. Arnott, were you desirous of raising a matter?
I was, Commissioner. Commissioner, you asked Ms Barnes some questions about the letter that she received from the Commission on the 11th of June. We seek to, we've obtained that document since you asked that question. We seek to tender it.
Well, I think it should become an exhibit, and if you would provide my associate with a copy, I assume Counsel assisting has seen the document?
Yes, and we have no objection to that course.
Very good. Thank you. The letter from the delegate of the Commissioner of the Aged Care Quality and Safety Commission to Ms Deborah Barnes, dated the 11th of June 2019, will be Exhibit 843.
Commissioner.
Will you arrange for multiple copies of that document to be produced?
Yes, indeed, Commissioner.
Yes, thank you, Mr Knowles. Yes.
Commissioners, I now seek to call the final witnesses for this week of hearing, and they are Professors John and Valerie Braithwaite. If they could come to the witness box now.
Do you wish to make an oath or an affirmation?
Affirmation. Affirmation.
Please repeat after me. I solemnly and sincerely...
I solemnly...
Sorry, do one and... Thank you,
you
sorry.
go first. I solemnly and sincerely...
Declare and affirm...
Declare and affirm...
That the evidence I shall give...
That the evidence I shall give...
Will be the truth...
Will be the truth...
The whole truth...
The whole truth...
And nothing but the truth.
And nothing but the truth.
Thank you. I solemnly and sincerely...
I solemnly and sincerely...
Declare and affirm...
Declare and affirm...
That the evidence I shall give...
That the evidence I shall give...
Will be the whole truth... Will be the truth...
Will be the truth...
The whole truth...
The whole truth...
And nothing but the truth.
And nothing but the truth.
Thank you.
Thank you.
Commissioners, before proceeding further, I should note that Professor Tony Mackay was to give evidence with Professors John and Valerie Braithwaite today, but cannot do so for personal reasons. May I formally request that she be excused from compliance with her summons to attend today?
Yes, Professor Mackay is excused from attendance at the Commission today on her summons.
Thank you, Commissioners. Now, can I ask each of you, Professors Braithwaite, to tell the Commission your full name, first off?
Professor Valerie Braithwaite.
Yes.
John Braithwaite.
Yes. Now, you have prepared a statement with Professor Mackay, is that correct?
Correct.
And do you have a copy of your statement with you there before you?
Yes, we do.
Yes. And have you had an opportunity to read your statement in recent times?
We have.
Yes. And the statement is undated, but did you provide that to the Royal Commission on the 3rd of August this year?
Correct.
Yes. And that is the document, I should say, Commissioners, RCD.9999.0149.0001. Now, are the contents of that paper that you have prepared true and correct to the best of your knowledge and belief?
Yes.
Thank you. Seek to tender that paper prepared by the Braithwaites and Professor Mackay.
The document entitled Answers to Questions Posed by the Commission to John Braithwaite, Valerie Braithwaite and Tony Mackay will be Exhibit 8-44.
Now, if I can start with you, Professor John Braithwaite, Could you please tell the Royal Commission what your present position is?
I'm a professor at the Australian National University in the Regulatory Institutions Network, these days known as the School of Regulation and Global Governance, which Valerie and I were the co-founders. Do you want us to say some more about...
That's your present position at the moment?
Yes.
And Professor Valerie Braithwaite, can you tell the Royal Commission your position?
My position is the same in the Regulatory Institutions Network, now known as the School of Regulation and Global Governance at the ANU.
And you both founded that body, yes. And can I ask you, Professor John Braithwaite, to indicate to the Royal Commission some of your past experience and expertise?
Val and I, together with Tony Mackay and Diane Gibson, were consultants to the Commonwealth Department of Health and Human Services. I think it was initially called in the late 1980s through to 1993, and produced a number of reports for the government on the quality of aged care. We're both regulatory generalists, I guess. Have not stayed actively involved with aged care all the way through. There was a long period of our lives where regulation of aged care was our main research topic, but in recent years, Valerie's done an inquiry for the Minister for Education on regulation of universities, on regulation of vocational education and training for Minister Birmingham as well. And I've been involved in other areas such as environmental regulation. So we have broad experience of regulation. I was a commissioner, part-time commissioner with the Australian Competition and Consumer Commission for 10 years.
It's fair to say that you have both taken up various esteemed academic and consultancy positions in Australia and overseas for decades. Yes, you're being unduly modest, I think, Professor Braithwaite, but it's fair to say that you are leaders nationally and internationally in the field of regulatory theory.
Well, Valerie is.
I think
you've published
fair enough to say that.
Numerous articles and books of great renown in that field for a considerable period of time, haven't you?
Yes.
Yes. And as you've indicated already, you both studied aged care and its regulation intensively for about a decade prior to 1997, and perhaps somewhat less intensively for the decade after that, you say in your statement.
That's right, yes.
And that culminated in you, together with Professor Tony Mackay, producing and writing and publishing the book Regulating Aged Care, Ritualism and the New Pyramid in 2007. Yes. Now, before I proceed any further, I understand that you wish to say something in respect of Professor Mackay at the outset of giving evidence today.
Yes, I'd like to say something introductory on behalf of Val and I. Tony Mackay was such a major contributor to our program of research across the decades on the regulation of aged care, and it was so important to her to be here today, partly in light of her mother's recent struggles with issues of aged care quality, but she's sitting beside her mother at the moment in the Ainsley Goodwin aged care home, where she's at the latter stages of palliative care. And I said to Tony, was there anything that you would have wanted us to say today? One thing that Val and I want to say, that we know Tony wanted to dedicate her testimony here today to the memory of her mother, Veronica Mackay, and we hereby do that. And Tony said in reply to our question, well, you know, my mum is the beneficiary of some significant improvements in quality of palliative care in Canberra, where she is having her palliative care in place in her aged care facility, where the palliative care nurses are coming into the home from the Clare Holland Hospice. And that really is you know, such a valuable thing. We've said in our submission that regulation of pain management is not one of the greatest strengths of the Australian aged care regulatory system. But here we have an area of improvement that has been happening in Canberra in recent years. But Tony wanted to say that sadly this is not the case, and our own quick research indicates that this is not the case for most Australians. So we would like to say that what has been a right for Veronica Mackay to get that end-of-life palliative care coming into the aged care facility, supporting those nurses to provide it in her aged care facility, should be a right of all Australians, even in the most remote rural areas.
Thank you. Now, returning to the book, Regulating Aged Care, what were the key aspects of aged care regulation that you explored in that book?
The work that was published in 2007 in the book was an accumulation of the 10 years of research in the 90s, papers published mainly by John and Tony together, and it made the point that relational regulation was what made the difference for aged care facilities in improving compliance and improving the quality of care. And by relational regulation, I mean it was what was happening in that particular aged care facility. It was the interactions that were occurring between inspectors who were behaving like detectives and working out exactly what was going on, joining the dots, and the management, the provider, and the staff. So the improvements came when they all came together, and the regulator assumed the role not just of calling out inappropriate behaviour or breaches to the standards, but also motivating everyone in the home to get on and improve the situation in a sustainable and continuous way. So that was really the special contribution, I think, of that particular volume.
And did the book compare the situation in Australia with other jurisdictions?
Yes, it did involve field work in the United States and in field work in Britain, and that was compared with Australia, and John did supplementary work closer to the publication date to make sure that our findings were still relevant when that book was published in 2007.
And what conclusions did you and Professor Mackay reach in the book about the efficacy of aged care regulation in Australia?
We found a result that has been considerably replicated in other areas of regulatory practice. People are often cynical about the effectiveness of regulation, but we found that regulation did contribute to the quality of care, and it contributed in a great variety of ways. What the current literature that's built on that and replicated a lot of our quantitative results, which were mainly based on an analysis of following up over a period of years of 410 Australian aged care facilities, is that deterrence is important in achieving regulatory compliance, but it doesn't work on its own. A strategy that's based on achieving compliance through deterrence threats is ineffective in the recent University of Maryland meta-analysis, but it is effective in combination with regulatory mix. It's when you have a mix of regulatory strategies. We found in our work evaluating Australian regulation of quality care, it works very much at the street level. Most of the effective work is done in a very informal, relational way by the assessors who go out and engage with that conversational regulation on site, and then send appropriate cases up for more serious enforcement engagement.
In terms of that relational regulation that you described, does that mean that in cases where there might be a team of assessors that go to a particular facility to assess compliance, it might be more desirable to have at least one assessor who has actually been to that facility previously and dealt with staff and management previously? Is that what you're getting at in terms of the relational regulation as such?
Very much, yes. Very much. You can't logistically have the same team going back to the same facility every time, but if you have at least one member of the team who provides that continuity, then the relational aspect of the regulatory conversation can be continuously advanced, and the kind of agility and wisdom that Professor Patterson spoke of in his testimony can be delivered. You can also have that when you have a team, that hard cop and soft cop thing that you sometimes need. You need regulation to be firm and fair, and sometimes very firm indeed. But when you've got someone giving that very tough message and someone else saying, encouraging relational messages, you can improve. And indeed, our research shows that when the team does come back later on and sees improvements, one of the cheapest ways of achieving improvement in quality of care is when the assessment team offers informal praise. It costs the government nothing for that team to say, you've still got some problems, but gee, you really got on top of this problem, and you can, these two nurses who took the lead in that improvement initiative, they deserve really serious praise. That works. We showed when that happened with inspection teams, quality of care improved 2 years later.
That actually brings me to the next matter that I wanted to ask you about. The book that you authored with Professor Mackay refers to the new pyramid. By that I take it to refer to the concept of a regulatory pyramid in which you are fundamental to. The pyramid as such has typically in the past been a pyramid of sanctions, but what you're referring to also is a pyramid of supports. Is that right?
Yes.
Yes. And before I go any further, can I ask for the document which is added to the general tender bundle at tab 155 to be brought up on the screen? Do you see that there? That's a document I think that you have prepared yourselves. Can you just explain that document in terms of what it represents by way of regulatory pyramid?
Well, the idea of the regulatory pyramid is you have a presumption in starting at the base of the pyramid. You can override that presumption if there's an imminent risk. For example, you want to move immediately to a higher level of the pyramid, but the presumption means that you always ask yourself the question, could we deal with this problem at the base of the pyramid with nothing more than providing capacity development for our service providers, and by assuming that they will want to learn how to do it better, how to do it right. And if they are doing it worse and doing it wrong, we might be able to convene a restorative conversation about what we've learned from the mistake, the complaint, as came up earlier this morning with your intervention, Commissioner, in asking the question about sharing information. So if you have a complaint, it could go back to a regular care planning committee meeting, which would, you know, is something that can occur in the form of a restorative justice circle where there can be sharing of all of that information, as it were, as an alternative to putting... I'm stealing your thunder here, Valerie, because you made that point as the Commissioner was asking that question. So then if that's not working, you can move up to deterrence and tougher deterrence if you're not getting compliance, up to incapacitation, which in criminal law we think of as we put people in jail so they no longer pose a threat to the community. Here it's more about taking out of the system directors of nursing or administrators who are not capable of providing a safe and effective environment and a caring environment for our elders, or removing accreditation.
Can I take you to the next page of this
Did you want to add
tab
something?
of the tender bundle, and perhaps then I'll ask you, Professor Braithwaite, to add anything as you see fit. We'll come back to this tab in a moment.
Yes. I think it's very important to recognise that the capacity building at the bottom is not done with ignorance on the part of the inspectors. In fact, there could be a death in the nursing home or in the aged care facility, but and there could be formal legal proceedings that will continue, but you can still have a capacity building exercise at the bottom of the pyramid if your provider and management are willing to be learning citizens and come to you and say, we don't want this happening again, let's do what we can to fix this up, even though we know there's going to be a court case or whatever legal action is going to happen further down the track. So I just want to make that point, that it's not it isn't an easy opt-out, we'll do capacity building because we haven't done our detective work well. You've always got to do that detective work very well to be using these pyramids.
Yes, and in terms of a pyramid that was developed, I understand, by yourselves some considerable time ago, but in respect of aged care, is that an example of such a pyramid there on the screen now?
Yes.
This is a very old PowerPoint, obviously, but this was what we were sending to the various ministers that we were answering to in the providing our reports to in the early 1990s, and these things have been put in the pyramids in different ways. I know it took a long time before suspension of benefits for new residents was actually being used, and we still don't know how much it's being used, or we don't, but I'm sure the department does. But yes, these were not in place at the time of our work, but now they are.
Yes, and you mentioned earlier praise and the place that holds, and if I could move to the next page of the particular tab, this is a diagram which incorporates both a pyramid of sanctions and a pyramid of supports, yeah. I take it.
Yeah.
Yes.
It's actually, we kind of like this, but more importantly, practical regulators tend to like this diagram better than the one we produced in our book, which was actually two pyramids side by side, a pyramid of sanctions, a regulatory pyramid, and a pyramid of supports. So you would escalate supports to encourage excellence. And This particular diagram is being picked up by a number of regulatory agencies around the world these days. This one was taken from South Australian Environmental Protection Agencies, and you see the nice green supports where we have champions on the far right side. So the idea is that you improve quality of care not only by doing something about the bad guys, if I can put it that way, but also encouraging the good guys to take quality of care up through new levels of excellence. And the idea is that if champions on the right side of this diagram are taking quality of care up through new ceilings of excellence, they actually drag up the bottom dwellers with them. You know, they raise the average standard. So it's important at both ends to have an integrated strategy of this kind. But with tough stuff, of course, in the regulatory regime under discussion with the Commonwealth, at least there is not access to criminal sanctions. We think there should be, but there's not. Yeah.
Are you aware of that recognition and rewarding of champions in aged care regulation as such now?
Yes. I served for a number of years on an awards committee that the accreditation body had in place, and in some ways they could have made better use of that to convey strategic lessons by explaining with more precision what it is that is excellent that others in the industry should be following. So excellence in regulation is, risk management is the bread and butter of good regulation, but seizing opportunities such as the opportunity to develop capacity across the industry by saying, here's a form of excellence, the rest of you seize the opportunity to follow it and become better in the way they have become better. That's important too.
And it's also the way to breathe life into continuous improvement. When you find something that's been done that's quite outstanding, then that can be the model for others to follow, and they can, if they're wanting to pursue that as part of their continuous improvement plan, they can. It's not a ritual of continuous improvement, it's a genuine commitment to continuous improvement.
Well, you raised the concept of ritualism as such. Can I perhaps move to that? What do you mean by ritualism, not just in continuous improvement as such, but in regulation more broadly?
Ritualism means a process that's focusing on the means for achieving an outcome while losing sight of the outcome itself. So the feeling that you're doing something terrific by following some protocols, for example, when in the particular context, the following of the protocols does not deliver safety and quality of care.
And how do you think that concept of regulatory ritualism applies in the context of aged care regulation?
Consultants that come in and use tick box instruments to create evidence, constructing something that's a pretty routine kind of thing as evidence of continuous improvement. The gardener leaves, and this is probably a very unfair example, but to clearly explain the concept, the gardener leaves and a new gardener, they have to be replaced, and the new gardener, there's this narrative about the great landscape qualifications this new gardener has to improve the quality of the experience of residents walking around. So all of these things can be seized upon as an opportunity to demonstrate continuous improvement when it's really just a routine replacement of staff.
Do you see that concept of regulatory ritualism in aged care even beyond the area of continuous improvement?
I would say so. I would say using categories to describe what's wrong in a nursing home is a form of ritualism. With ritualism, we are wedded to, sometimes it's collecting particular bits of data, filling out forms, and we don't have time to sit there and think about what we're seeing and connecting the dots. So for an investigator of any kind, the important thing is to sit down afterwards and look at their notes and think about what all of this means, to try to create a narrative about what they've seen and what they've written down. It's somehow a ritualistic filling out of forms, writing reports in a certain format, collecting certain pieces of data, interferes with that thinking process of a regulator taking agency to say, I want to know what the narrative is, I want to know what's going on. I think we see that in a lot of areas of regulation.
Are you aware of the evidence that has come before the Royal Commission earlier this week that referred to computer-generated template rationales for findings in audit reports and the like?
Yes, it must numb the minds of regulators. It must mean that they simply are not thinking about what they've seen, the information in front of them, and getting that narrative together.
We were pleased to see that was abandoned, but it's also an example of a misplaced emphasis on consistency, because it was justified in terms of consistency, but it's a very ritualistic form of consistency, the kind of consistency you don't want to have in a responsive regulatory regime, because you really want people to be thinking in time. I guess the most troubling and recurrent form of ritualism is just the signing of a care plan without reading it and without participating in a care planning meeting as residents and relatives and all of the carers involved in that particular individual's future.
I think another form of ritualism that we saw in the transcripts was the assumption that it was this decision about a standard being met or an outcome being met or not met. It was quite clear that if there was no indication that a standard, there was no indication that a standard was met. The goal was simply to find examples of it not being met. So if there was an example of the standard being not met, then it automatically became a met. There wasn't active evidence to show that the standard was being met. Did I get that straight, or did I get that muddled up with
Theresa
my
May
would put
it.
That was my Theresa May.
Met means met. It doesn't mean there's not evidence of it not being met. That's a real problem.
I think that's an example of ritualism, because if you think about it, you come back and say, well, that standard was met. Oh, I didn't see evidence that it was met, but then there was no evidence that it was not met, so it must be met. So that logic, if you think about it, is not a very sound logic at all. So I would put that down to ritualism coming into the system and it not being questioned because no one's thinking about what the outcome is, which is to assure everyone that the quality of care is high in that particular aged care facility.
There was also evidence earlier in the week about a difference of approach taken by assessors attending on site at facilities depending upon the particular type of visit that was being conducted. So if it was a review audit and there was some concerns that had been raised that led to the review audit, there was a more vigorous level of scrutiny. But if it was a re-accreditation audit, that might not be the case. And do you see that as having implications in terms of the ritualism features that you describe?
Well, I mean, it's a good thing that there is a certain kind of amount of triage for more serious cases of concern, having more individuals going out on the visit to the facility, having longer at the facility. That's a good aspect of the review audit, but it's very important that not give the message that when you have a standard accreditation, that what's expected in terms of met means met. It doesn't mean just if we don't happen to see anything bad on our quicker look around that we feel that we're able to use a bit of standard language and communicate falsely, I would say, the message to consumers that there has been an assessment, and the assessment is that the place is met. I mean, it would be like our university. You're hiring someone who is a graduate out of our university, and they send you the transcript, and it says that they got 100 out of 100 on all of their assessments at our university, and we would hope that you would be impressed by that. But if our practice was to give them 100% on every assignment, if we couldn't see anything particularly negative there, I think employers wouldn't be very satisfied with that.
Yes. Well, that brings me to another point. You may have heard the evidence during the week that was, I think, mentioned in the opening address by Senior Counsel Assisting, that in recent years there have been around 98% of all facilities or services being assessed as meeting 44 out of 44 expected outcomes across the accreditation standards. What does that say to you about regulation of the aged care industry?
A risk of ritualism. We noticed also that there was some testimony that came to you that said in the self-assessments by the facilities, they always gave themselves 44 out of 44. So that's a self-assessment that's not working. You can't find anything that you really need to do important things to improve on. It's not a genuine form of self-assessment. So it is very worrying in being a false form of transparency. I mean, when we were looking in aged care facilities in Canberra, we'd go to the website and it looks like all of the facilities that we could send our parents to look perfect. So it's giving no information to consumers. It's giving no feedback to facilities as to when they're doing better and when they're doing not so well. It makes the praise less meaningful when they're having this view of themselves that we've got a perfect score, we've got, you know.
Well, do you think those figures suggest that the regulator is afraid to give negative feedback or reports to approved providers?
It's hard to make sense of it in other ways. I mean, we can make some sense of it in terms of the research that we did a long time ago, in that way back then, in our work on capture, we found that capture was not as big a problem in this arena as it is in some others, at least in the sense of a revolving door. That is to say that assessors who came, standards monitors who came from the industry, were not a lot less tough than those who had not come from the industry. So that revolving door part of the capture problem was not as serious as in some areas. But the other interesting result there on the other, those hoping to go into a job in the industry were a bit softer and gentler in their assessments, but not a massive effect, I would say, compared to other regulatory regimes. But those who were tougher and more demanding and were wanting to have more standards rated not met were more likely to leave. So they got they would get discouraged and leave. And that's a dynamic that you have in regulatory agency, all regulatory agencies, I would say, but we certainly see that in the aged care regulation arena in Australia, that those who are more demanding get disappointed and leave.
And does that have flow-on effects?
Yes, because it means the culture then of the regulators is not one of calling out inappropriate behaviour. There's also some suggestion in the literature that social services in general don't like to see themselves as being regulated or having regulators. It's a helping profession, and so the notion of regulation is a bit of a dirty word, but that clearly should be resisted, and particularly our view of regulation, which is not just saying this is inappropriate, but making sure that people have pathways to pursue and correct the inappropriate actions and also the support to do so. So that could be part of the explanation, but then that doesn't gel with the Banking Royal Commission, of course, because they don't see themselves as social service providers.
And in terms of industry capture, though, putting to one side the people working at the coalface who are in the positions of assessors, are there other areas where you have perceived industry capture in the aged care regulatory framework?
Well, we're a bit out of touch with that aspect of it, but certainly back in our day when we were working intensively in this area, it was certainly the case that people in the department were afraid of certain dominant providers in the industry and worried about their political clout. There is evidence out there of political donations by providers, and that's a recurrent theme in all regulatory regimes. It may not be as big a problem in this area as it is in regulation of gambling or all sorts of other areas, but in our view at that time, up to 2007, there was clear evidence of that. What we didn't see evidence of on the positive side is we did not see evidence of corruption in Australian aged care regulation. And I mean, usually we do when we're working in regulatory areas in Australia and elsewhere. And we certainly saw it in aged care regulation in the United States. I mean, there were cases of convictions of operators of nursing homes providing a packet of plain envelope of $100 bills to inspector nursing home inspectors, and being convicted of that, and lots of rumours around of other examples of that happening, and that being believable. Facilities owned by the mafia and so on. Remember the story of an exit conference where the owner put a gun on the table during the exit conference? Well, we haven't had those sort of, that level of corruption problem to our knowledge up to the time when we were working, but we think there were quite worrying other levels of capture and concern about the political influence of the industry. And indeed, in retrospect, we kind of think that the whole idea of setting up an accreditation agency that was separate from government regulation was a wish that the industry was lobbying for a long time, and that was, the politics of delivering to an industry something they wanted to get regulators off their backs who they weren't totally happy with. And I mean, we're pleased that the present government is moving in an opposite direction and accomplishing some reintegration of the accreditation function and the enforcement function, which in our view has to be better government.
Just for clarification, the exit conference is not about terminating anyone; it's about debriefing the nursing home on the findings of the inspectors.
Yes, thank you for that. On a related issue, you in your 2007 book referred to enfeeblement of enforcement in the Australian aged care regulatory system. How do you see that manifested in Australia as distinct from perhaps other jurisdictions like the US and the UK?
Well, obviously, we don't have criminal penalties. We don't have enforceable undertakings. I mean, I have some background in the ACCC. I hope this doesn't indicate my capture by the ACCC, but I think a lot of regulatory thinkers would have the view of the Australian Competition and Consumer Commission as having the record of the highest enforcement competence of any regulator. I mean, the Hayne Royal Commission said as much in its report, and so I think we learn from cases like that. I've lost track of your question now.
No, I was just asking about enfeeblement of enforcement. Do you think that is actually manifested in the aged care regulatory system in any way? In particular, do you think that you've mentioned the absence of certain measures? Do you think that the regulatory toolbox has enough in it for people to successfully regulate the industry?
The kinds of measures that John has mentioned means that the expectation of improvement is taken more seriously. If you think you're going to have an enforceable undertaking or something worse, then you listen and you act more readily. So, and that's the idea of the enforcement pyramid, that you know that if you delay and you don't do what you're supposed to do, there are consequences that will hurt you down the track. So it pushes a more resolution of problems to that level of dialogue and discussion and residents' committees, etc. It's in the interests of the provider and the management to actually solve problems at that level. You don't get that effect if a provider or a provider or the management feel that they can cover up the problem and keep batting the problem back to government or to the regulators.
So you might say, what's the difference between an ACCC enforceable undertaking and the aged care regulator requiring a continuous improvement plan, which is ratified by the regulator, and then the regulator assesses whether it's implemented? Well, one reason why the enforceable undertaking is a step up the regulatory pyramid is that it's court sanctioned, so that if the provider doesn't comply with the enforceable undertaking, it's contempt of court, and that's a criminal offence as well. So you track back to the power, including the symbolic power of the criminal sanction having a useful role in aged care regulation. That's not to say that you want criminal prosecutions all over the place. We would like to have more criminal prosecutions, particularly for matters like sexual assault, of course, without fully individualising it. We want the facilities that allow the sexual assault to occur to be also held to account at the same time the individual criminal offender is, but the symbolic power of the criminal sanction is, we think, useful, and of course that's not available under the current legal regime.
Can I just ask some final questions of you in relation to one of the matters that you raised, Professor Valerie Braithwaite? You raised in relation to resident councils or resident representative bodies. How useful do you see them as being in terms of complementing a regulatory framework?
I think they're absolutely essential for holding the facility to account. There's been discussion of transparency. I think that's very important too. It's not that transparency in and of itself produces change, but transparency combined with voices of how change can occur, as well as muscle to make that change occur, is a very effective strategy. I can understand the concern about reputational damage, but the reality is that if you are an open and transparent provider, your residents, relatives, friends, advocates will know that. So even though you might have a moment of great embarrassment and humiliation, because of your past history of being an open and transparent provider, they will rally behind you and you will overcome your problems sooner than you would otherwise by keeping them secret. So I'm a great believer in strengthening that capacity. And I do think at the moment it sounds as if a lot of people who are interested and are willing to hold the system to account are being denied information, or they're being silenced by just wearing them down with the enormous lengths of time that it takes. I don't think it's reasonable to put the onus on residents' families to always have to keep complaining, for instance. They're trying to provide the best quality of life for their resident in difficult situations often. So to be expecting them to be making the phone calls, to keep making the complaints, to have that persistence, I think is unreasonable. And I'm sure many of them get worn down or decide that the priority is to just spend their time with their relative and try to protect them as best they can.
Yes, thank you. One last question of you, and that is in relation to complaints and what you've just mentioned about the need for people to make complaints to get things done. Do you think that there is too much reliance in the aged care regulatory framework on complaints in order to uncover deficiencies in care?
Absolutely, yes.
And how would you remove that undue reliance on complaint making otherwise?
Well, spending more time in the nursing homes, using the eyes and the ears of residents to be meeting for their care planning meetings. I think care planning meetings are underutilised. They can be used to sort out all sorts of problems that a provider might be quite willing to sort out when the problem is new. That if they can do it there and then, anxieties, tensions, different views aren't allowed to cause disruption to the relationship. As we were hearing, the relationship is better if problems are solved in these care planning meetings, for example, at the time that they occur. I think if that was working more efficiently, then the number of complaints that would actually be made to government would be fewer. It's the fact that they're not being resolved at the time locally that I think is part of the problem here.
Yes, so we think there's particularly heavy reliance on complaints with home care because it's so difficult to have an inspection process for home care where you arrive unannounced and you're not going to find the home care provider in the home. So that standard kind of inspection approach doesn't work, but nor does it work to encourage people to send in complaints with a bit of a ginger up of encouragement to do that just before there is an audit process for the home care provider. Complaints are important, but again, go back to Professor Patterson's testimony, the need for pulling complaints together in an agile way with other sources of information, quality of care indicator information, and we think that at all levels, in a relational approach to quality of care, it's important to empower the street level assessors more than we do, to move away a bit from the culture of, say, my job is just to see what I see. If I see any problem, to report it, and albeit to report it in an excessively templated way, and then someone in central office, as it were, takes care of it and decides what to do. What we want is, what we're advocating in our submission is a more detective-oriented approach on the street, as it were, that they are taking the initiative to seek out evidence from complaints, to seek out evidence from advocacy organisations, from community visitors, looking diagnostically at the quality indicators, coming to a view holistically about whether this is a high-risk facility or not, and having those conversations. And in terms of ritualism in continuous improvement, what Val is talking about is kind of a big part of the solution there. So if you have, from the most micro level of care planning meetings where relatives, and under the US regulations, the relative has a right, gets a letter of invitation to a care planning meeting for their relative, and so this in effect mandates that the care planning meetings have to happen on a regular basis, which is not the case in Australian aged care facilities, but also the Residents' Council. And in these forums, so if there's a form of continuous improvement ritualism going on where some phony documentation has been created to demonstrate continuous improvement on some outcome, an advocacy organisation can come along and have sought advice from a competing consultancy provider. And so these can be the fora where there can be openness and critique of shoddy continuous improvement work, with support from other consultants who have a different view and say, this is not the best way to demonstrate this kind of continuous improvement. This is not something the regulator should be accepting. This is not something the facility should be accepting. This is not something the home care provider should be accepting. So in particular with home care, we think that it's necessary to actually have more conversations with those who use home care services, rather than send them a letter to say, if you've got any complaints, write in now. That's not going to work.
I have no further questions, Commissioners.
Only one from me, and it's this. As you work your way up the second of the pyramids and map out how to deal with recalcitrant providers, you come up against the possibility of imposing short-term sanctions whereby they can't take on any more residents until they've corrected the problems that have been identified. The next step, however, is that they can't take new residents on for a protracted period. And when you get there, I see some incongruity, because what you're doing is saying, well, the ones they've got, they can stay, despite the terrible situation that has led to the imposition of the sanction, whereby we're not going to allow anybody else in for a protracted period. How do you resolve that conceptual problem?
You're making a good point there, Commissioner, but there are two, on the other hand, points. One is that when you're not, it's very resource intensive to bring new residents into the facility. So when you're not taking in you're concentrating such resources of you as you have on the people that you have who are already there. So that mitigates your point somewhat. The other one is, as tempted as we might be a lot of the time to close a facility to protect those residents who remain behind, there is quite a bit of evidence that moving people even to a better facility can result in worse outcomes in terms of mortality and morbidity. So it would normally be better regulatory practice on the balance of all of those considerations to prefer the lower step down the pyramid of pressuring in some way, using some appropriate regulatory lever, the replacement of the management team. So you get better management in solving those problems, or better training of lower level staff in solving those problems to protect those who remain.
I think more generally the point is that the regulators will engage in other strategies to find that pathway forward while that sanction is there. It's never going to be one sanction that works. It's really a matter of using many sanctions and also carrots actually to try to get things back on track. But as I think you're suggesting, it doesn't always work.
Well, thank you both very much. We have learned a great deal in the last hour, and the good part of it is that it comes from people with a depth of experience of the industry, but from people who are not captive by any of the competing interests in the industry, and we're very grateful for the independence of your well thought through views. We would extend our felicitations through you to Professor Mackay and thank her for her courteous explanation of her absence and her contribution to the information that we've received this afternoon.
Thank you, Commissioner.
Thank you both very much.
Commissioners, apologies. I've been asked by Council for the Commonwealth to raise a couple of matters very quickly.
Yes,
with
certainly.
the Braithwaites. They're just questions requiring a yes or no answer. Can I ask each of you, have you accompanied any assessors from the Aged Care Quality and Safety Commission in their conduct of assessment contacts or audits?
As we explained in our commission, our on-the-ground research ended in 2007 and predates the existence of the commission.
Yes. And I take it, therefore, that you haven't reviewed audit methodology documents in recent times? No. Produced by the aged care regulator?
Well,
I have a little, but we would not claim to be, our reflections, as we want to emphasise at every point of your questions, reflecting back on the data that we had from our empirical research.
And I think we are reflecting on the testimonies that we've heard while we've been here.
Yeah, we listened to the testimony. We certainly learnt things from that we didn't know before about things that have changed, such as this negative, giving a MET rating on the basis of there not being negatives that came into your testimony. That was our source. The commission hearing was our source for that view.
And did you read any of the documents, like the actual decisions that were the subject of that oral testimony yourselves? No? I
don't understand the question.
So that you've referred to viewing oral testimony in the Royal Commission.
Yes.
Have you read any of the documents that were the subject of that oral testimony insofar as they were decisions or reports produced by regulators?
I don't think we made any comments on particular decisions.
Is that enough? Thank you, Commissioners. I appreciate that.
Second time lucky. You're excused.
Thank you.
Commissioners, if the Braithwaites may be excused, I'll just proceed straight into the closing address.
Please do.
Thank you. The evidence this week has exposed serious defects in the regulation of quality and safety of aged care at both the operational level and the design level. Equally concerning, these defects are old news. Government has been tardy in implementing previously recommended reforms. There's been no sense of urgency. Government is yet even to reach a decision on aspects of the actions that have previously been recommended by Carnell-Paterson. Government has been unable to deal with the challenge posed by the need for reform, or at least to do so promptly. Critical, urgent reform tasks have been outsourced to consultants and appear to be mired in protracted and multi-staged industry consultation processes. Inside the department, officials are focused on policies and procedures being in place, standards being met, timing and formal processes. On the evidence this week, a spirit of inquisitiveness and curiosity appears to be sadly lacking. The evidence indicates that some, but perhaps not all, regulatory functions will be transferred to the new Aged Care Quality and Safety Commission, which I'll be calling the Quality Commission, with effect in January 2020, subject to necessary legislation being passed. The Secretary of the Department, Ms Beecham, told you in February that the concentration of regulatory functions in the Commission's hands in January 2020 is likely to involve the transfer of the departmental workforce who currently exercise those functions. That being so, Commissioners, there's no guarantee of cultural change without a transcending intervention of some kind. In any event, a similar focus on process over the spirit of inquiry also seems to pervade the Quality Commission in relation to those functions it has already assumed. For example, you heard the extraordinary evidence that until recently assessors of residential aged care facilities prepared their reports with computer-generated templates which contained a large number of template rationales for findings or assessments. In our submission, much of the evidence this week points to a process-driven approach to accreditation, the very approach critiqued in Carnell-Paterson, which was published almost 2 years ago. The failures of the regulators, I'm referring to both the Department and the Quality Commission, to respond to clear and present risks in the Earlhaven matter are failures in responsive regulation of the kind identified by Carnell-Paterson. In the MyCare case study also, the Commission heard evidence about what appears to be inconsistent quality assessments undertaken by the Quality Commission, which seems to have been adhering to the kind of monitoring process critiqued by Carnell-Paterson. Returning to the Earlhaven case study, you heard evidence about the numerous risk factors that People Care, the approved provider, had presented over a number of years. As Mr Speed conceded, if all the information had been put together, this might have indicated to the Department that a more immediate response was warranted. Now is not the occasion for a detailed closing address as to the proposed factual findings in the case studies. Commissioners will be doing that in a written submission after the hearing in accordance with the directions you've made. However, the point I make about failure to appreciate risks raised in the course of different functions being exercised by different officials can be demonstrated from the following facts in the weeks preceding 11 July 2011 in the Earlhaven case study, even without considering the long history which preceded that time. The first fact, the complaints section in the Commission had received a number of complaints. One, dated 5 April 2019, referred to attempts to address inadequacies and failings at Orchid House since June 2017. And I quote, "Despite this, we have been unable to progress any meaningful and lasting changes to care. The situation under the current lessees, Help Street, has become untenable. Help Street is about to sign another 5-year lease contract with Miller Enterprises and this concerns us greatly," end quote. It appears that the complaints section in the Quality Commission was provided by this complainant with minutes of the recent relatives meeting at which a number of complaints about service and staffing levels had been aired. The second fact, the complaints officers of the Quality Commission attended a meeting with Arthur Miller of People Care and Karen Parsons of Help Street on 30 May 2019, from which it was obvious that the two companies were not communicating about the issues raised by the complaints. This meant there was a breakdown between the entity that was subject to statutory obligations, the approved provider People Care, and the entity with the practical ability to do something about those issues, Help Street. The third fact. In the meantime, the Prudential Compliance section of the department had been attempting to obtain missing information about prudential compliance from People Street for months, after a notice of non-compliance had been served in January 2019, which resulted in only partial compliance. After months of attempting to obtain the omitted information, on 13 June 2019, a Prudential Compliance delegate decided to take no further action. The fourth fact. On 25 June 2019, an assessment contact was conducted by the quality monitoring personnel inside the Quality Commission, and that area of the Commission is separate from the complaints area. Those personnel were to follow up certain issues raised by complaints and incidents, and that's a positive. However, there were by now broader issues of concern about the functioning of the facility. One of the things the personnel from the quality monitoring area discovered during the assessment contact was an alarming use of chemical and physical restraints, with the level of the use of psychotropics at 71% and the use of physical restraints at 50%. The assessors did not broaden the scope of their assessment contact to respond to this information. It appears that these four facts were not considered holistically by the Commonwealth regulators at any time before the abrupt cessation of services on 11 July 2019, and that they had no contingency plan to secure the welfare of care recipients at Earl Haven, and in the end it was left to state emergency services to deal with that event. This morning, Ms Reid of the Quality Commission rightly acknowledged that the complaints area of the Quality Commission failed to show requisite curiosity and failed to communicate with the Quality Monitoring section within the Commission. It appears that the Quality Monitoring section itself failed to raise the alarm based on its assessment contact. We submit that the evidence establishes disconnections within the Commission, disconnections within the Department, and a disconnection between the Commission and the Department. And we submit that the aged care regulatory system does not have the broad, agile and integrated approach to risk analysis that is required. On the direct accounts and case studies this week, the regulatory system has failed adequately to consider and act on the views of care recipients and their families in relation to the care that they've received. Ms Laffin pointed to the recent replacement of the accreditation and home care standards with the single quality standards framework and the use of consumer experience reports, CERs. On their own, these measures will not achieve the required change. The Royal Commission has heard evidence in previous hearings raising concerns about the new standards. Further, only a small proportion of residential aged care recipients are engaged through the CER process, and then only as part of the accreditation audit process. Accreditation is a rare event, usually occurring only every 3 years. The imperative to listen to the voice of the care recipient must start in the facility or service. Ms Beverly Johnson told the Commission about the difficulties she has experienced in having her voice heard and respected in the aged care facility where she lives. When asked about representation of residents in aged care facilities, she said, "Well, I would say, what representation? There seems to be very little of it, and like anyone in the community, residents should have a right as to how you're treated. And residents, it would appear, once they pass through the front door of the facility, give up that right." That voice, that's the end of the quote, that voice must also be heard as part of the regulatory process. The Consumer Experience Report mechanism is still in its infancy in residential care settings. There's no statutory obligation to consult with recipients of home care as part of the quality review process at all. The requirements around consulting with care recipients in both residential and home care should be enhanced, broadened, and the results should be published. The Commission heard from a number of witnesses that they did not feel that the complaints processes responded to the underlying circumstances that led to their complaint or provide any satisfactory resolutions to their concerns. Ms Gwenda Darling, a recipient of home care services, said in that interaction with the ACCC, that's the Complaints Commissioner of course, I didn't feel like there was any compassion for me or concern about my experience. It felt like the woman I spoke to had a script to read and there was no personalisation. Ms Darling told the Commission that after trying multiple avenues to raise complaints, I felt it was useless to keep trying to complain, so I didn't pursue it. And as a as a home care client, I feel like no one cares. Associate Professor Sarah Holland-Batt, who gave evidence about her father's experience in residential aged care, said, I got the impression that the ACCC was inclined to work with the facility and accept its assurances and did not really intervene in the process and make suggestions about what measures might be appropriate. Ms Holland-Batt also said, I would like to see greater transparency regarding provider responses to complainants. We'll be outlining in further detail the evidence that was heard in relation to complainants. Ms Deborah Barnes also gave relevant evidence. Mr Jeff Rowe, the CEO of Aged and Disability Advocacy Australia, also gave relevant evidence concerning his impression that the Act reads like an overarching funding mechanism, and we submit that Mr Rowe's impression is the correct one. There's a legislative focus on providers' funding entitlements to the detriment of the rights of people receiving care. Commissioners, you should be guided by the evidence of Professor Ron Patterson, ONZM. He told you consumers and their families must be confident that there is a strong, independent complaints handling function within the Aged Care Quality and Safety Commission. The Complaints Commissioner must be highly visible in the aged care sector and more broadly in the community. It must be and be seen to be rigorously independent from regulatory functions. Its complaint handling must be skilled, timely and effective, and the lessons and trends from complaints must be well publicised, promptly and in user-friendly formats for consumers, providers and the community. Commissioners, you also heard evidence about the incident reporting scheme, and you heard a case study as to the assessment that occurs and the limited degree to which there's follow-up with providers. We'll be addressing that in written submissions. There's also the policy issue regarding the very major exemption to the compulsory reporting regime, which we addressed in the opening and we'll address again in written submissions. The current regulatory model of aged care in Australia falls well short of best practice standards and is insufficiently responsive to risk in the range of the interventions that it deploys. The Earlhaven case study shows that quality regulators and the officials with power to impose sanctions have been preoccupied with the question of compliance with minimum quality standards, the procedural steps that apply in cases of detected non-compliance, and with an apparent objective of managing approved providers back to compliance at virtually all costs. PeopleCare's status as an approved provider was not revoked despite repeated failures and a relapse after temporary improvements achieved under sanction in 2016 proved unsustainable. This led to further sanctions in 2017, but not to a revocation. And after this, of course, from about April 2018, the management and provision of care was outsourced to Help Street under arrangements that proved to be uncertain and led to commercial disputation this year and ultimately the events of 11 July. Commissioners, Professors John and Valerie Braithwaite have described the enforcement function as enfeebled. Numerous witnesses have identified the narrow range of sanctions currently available and the regulator's apparent unwillingness to use them. Witnesses have agreed that the regulatory model would be strengthened by having access to a wider range of sanctions, including potentially powers to hold directors personally to account. Evidence from direct experience witnesses also suggests that the available suite of sanctions do not provide for effective accountability. Ms Holland-Batt said, the solutions I wanted, consequences for the abusive carer, and assurances that she would never be able to victimise vulnerable patients in the sector again apparently could not be provided. What I wanted was some kind of penalty for the people responsible for what had happened to my dad. That's the end of the quote. At the same time as regulators have been unwilling to move to the top of the regulatory pyramid, there are also failings at the lower tier of the pyramid. The design of the regulatory framework has provided no incentives to excellence. Well-performing or excellent providers are not rewarded by a graduated scale of performance or by publication of that performance. Professor Patterson said, "Regulation is not just about setting minimum standards, it can be used to promote quality improvement." Professor Patterson agreed with the suggestion I made that an accreditation system relying on cyclical reviews, simply providing a met or not met outcome in which 98% of the relevant services meet the relevant standard, simply does not provide transparency for recipients or any incentive for providers to improve. Which to turn to home care. The regulation of the quality and safety of care delivered in the home is even less developed than the regime for residential care. You heard from Ms Laffin about gaps and weaknesses in the regulation of home care. She referred to the absence of any requirement for accreditation against the standards before the commencement of service provision. No statutory obligation to engage with care recipients when undertaking a quality review. The absence of visibility on actual delivery of home care. Reporting requirements which do not require home care providers to advise the department of changes to key personnel. And less transparency than in residential care, and I might add the absence of compulsory reporting of incidents at present. The evidence from Ms Laffin suggests that the department has, in the past, had the view that differences in the home care setting justified a weaker approach, but that view is no longer held. Commissioners, it appears that the department considered that under the consumer-directed care model for home care, market forces would act as a safeguard, at least to some degree. But you've heard in other hearings that consumer-directed care in home care is problematic in areas where information's not available to the care recipient, where services are thin, such as in rural, regional and remote areas, and where the care system is confusing and difficult to navigate. Quality reviews of home care services need not occur until a significant time after a provider begins operations, leaving a window of significant risk before the Quality Commission first scrutinises the service in question. Ms Gwenda Darling's opinion is that the home care system is broken and seems totally unregulated. She offered a practical suggestion for the regulation of home care, namely that home care users should be surveyed for their views on the quality of service as part of the quality review process. In terms of home care, we submit regulation is deficient, and it's unclear whether various foreshadowed improvements will end up protecting care recipients and address their overarching concerns and priorities. Commissioners, I want to turn to the issue of interactions with the system across a range of topics, complaints, advocacy and the like. You've heard about the difficulties that people experience in seeking to access and navigate the complaints system. Ms Hollenbat and Ms Barnes have said that they feel as though providers pay lip service to their complaints. They feel as though the complaints system does not extend empathy or concern, and they feel like the priority is to resolve cases and do that quickly rather than really address concerns. You've also heard about the difficulties that people face accessing advocacy and support services. Professor Patterson noted that when he undertook the review of national aged care quality regulatory processes with Ms Carnell, he thought that there was scope to strengthen advocacy services in Australia. He described it as a weakness in the Australian system. Professor Patterson gave evidence to you that the absence of a strong consumer voice in the aged care system is a notable feature of aged care in Australia. The voices of providers are predominant in the Australian system and appear to be highly influential in policy debates with ministers, departments, agencies and officials, but the voices of consumers, families and consumer advocates are relatively weak. Mr Rowe gave evidence that despite best efforts, we are only supporting less than 1% of aged care users. To me, that's extraordinarily frustrating, and what we're seeing is a real growth in demand for advocacy services. Ms Holland-Batt, who provided evidence to the Royal Commission about her experience supporting and advocating for her father, said, "So it would have been really helpful as someone who was new to this process to perhaps have someone, a disinterested party, helping me to navigate it or giving me advice or information, because my feeling was that the complaints officer was kind of taking the facility at their word, and so I didn't really have anyone to help me push back against that. So yes, someone perhaps, some function where people could be given some disinterested advice and support would have been helpful as well. Ms Gwenda Darling, who shared with the Royal Commission her experience with a number of home care providers, suggested that, and I quote, "It would be good to have people in a role like a guardian when someone commences with home care as a contact and advocate for them if they experience problems with their care," end quote. No regulatory framework is a guarantee against some bad outcomes, but the current regulatory framework has too often failed to listen to the person receiving care or their family, and has too often failed to detect risks and to detect and deter substandard care and other threats to the well-being of people receiving care. Our contention is that the current regulatory system, which is focused on processes rather than actual outcomes and is based on minimum standards, is unlikely to provide an adequate basis for improving the quality of care and welfare of care recipients. The regulatory model for aged care and the culture of the regulators needs to change. You've heard evidence about other approaches to the regulation of quality and safety in different but related sectors. Mr Graham Head's evidence with respect to the National Disability Insurance Scheme Quality and Safeguards Commission framework revealed significant contrasts between regulatory approaches in disability services as compared with aged care. The NDIS Commission's regulatory philosophy arises out of the objects and general principles set out in legislation, including the objective of giving effect to Australia's obligations under the United Nations Convention on the Rights of Persons with Disabilities. By comparison, it seems the aged care framework and regulatory philosophy doesn't meaningfully protect or enhance the human rights of service users. Professor Deborah Paconi, AO, Chief Executive of the Australian Commission on Quality and Safety in Healthcare, gave evidence regarding steps taken within the health sector to promote transparency and engagement of service users within the governance of healthcare services, with the intent of enabling service users to drive quality in the delivery of care. Professor Paconi gave evidence about the use of clinical indicators by the Australian Commission on Quality and Safety in Healthcare and the importance of that data in measuring quality, as well as giving early warning signs about something going wrong. She agreed that there would be no barrier to the collection and reporting on this information in the aged care context. Professor Paconi observed disparities between standards applied to clinical care in the health and aged care settings and suggested there may be opportunities for greater harmonisation of healthcare standards across settings. She told the Royal Commission, "Our view is there should be one set of core standards." The Queensland Public Guardian, Ms Natalie Siegel-Brown, observed that other systems such as disability, mental health and children's services are more advanced when it comes to promoting the voice of persons who interact with their systems and receive care, support or other services. She considers the aged care system is decades behind these other sectors. She said, and I quote, "It would appear to me that the aged care sector is where we were 20, 30 years ago with disability, when we had, for example, in Queensland, the Carter inquiry that gave rise to this need for regular eyes and ears monitoring the rights of people who very often may not have the cognitive capacity or the self-efficacy to advocate on their own behalf," end quote. Fundamental change to the regulatory system for aged care is needed. We submit that piecemeal adjustments and improvements are unlikely to achieve what is required. A philosophical shift is required, placing the people receiving care at the centre of quality and safety regulation. This means a new system, empowering them and respecting their rights. It should involve a different and enhanced approach to complaints and other avenues for the voice of the care recipient to be heard and for the regulators to respond to it. The Royal Commission has received a good deal of evidence about the importance of placing the person receiving care and their relationship with the care provider at the centre of decision making to ensure a good quality of life as well as appropriate personal and clinical care. The same philosophy should also permeate all aspects of quality and safety regulation. A person-centred approach to regulation would place the needs and aspirations of care recipients at its centre. It would have regard not only to the older person, but their family and the important people in their life. It would recognise the importance of the relationship between the older person and their care workers. We will be addressing further issues related to quality of care in future hearings and expect to hear further from the Quality Commission, from the Secretary of the Department and other senior officials to assist in our inquiries into aged care regulation. Commissioners, as in earlier hearings, you've made directions for the preparation of written submissions on the case studies or other matters arising in the hearing. Those directions have been published on the Royal Commission's website. Council assisting submissions are to be provided by Monday 19 August, responding submissions within 7 business days of the provision of Council assisting submissions, and any reply submissions within 5 further business days.
Thank you, Mr Gray. There will be directions to that effect on the website this evening. We thank Council for their assistance. We thank those who've been responsible for setting up this week's hearing here in Brisbane, which has been no mean feat. We thank the Family Court of Australia for making this courtroom and other facilities available to the Commission for the purposes of its hearings. The Commission's further hearings will be adjourned to Melbourne on a date to be fixed.
Olmsted. The Royal Commission is now adjourned until the 9th September 2019 at 9:30 a.m.